Good afternoon to all of you. All good. Revise the yesterday's class. Online students, is it audible? Good afternoon to all of you. All good. Revise the yesterday's class. Online students, can you all hear me? Okay, so we will continue with the remaining questions. So there are some miscellaneous areas apart from certain concrete areas we have to cover. We will cover, and then I have also picked some 15 to 20 important current affairs things. So only those are the most important thing. Nobody can exactly predict. From those also the questions are given. From a question point of view, I will just discuss, but if you want to work on those topics, you can work a little bit more. Okay, so this may be sufficient, but still if you want to work, you can just work on those areas where the questions has been framed. All right, I will just go to the next question. This is related to the Representation of People Act. If you see, UPSC also does ask one question from the Representation of People Act. So from the important areas, including some current aspects, I have framed some questions. Okay, so we'll just solve those questions. Which one of the following best reflect the legal position regarding the commencement of the election process in the parliamentary or assembly constituency? When do you think that the formal election process starts? After the election notification is issued. And who issues the election notification? Who issues election notification? The Election Commission or the President of India? For the Lok Sabha elections and the Rajya Sabha elections, it is issued by the President of India on the recommendation of the Election Commission. For the Legislative Assembly elections and the Legislative Council elections, it is issued by the Governor on the recommendation of ECI. Okay, so this is a very important area. This is what the Representation of People Act 1951 says. But even before the election notification is issued, what happens is the election schedule will be announced by the Election Commission of India. But the formal process of election will start only when the election notification is issued, which gives a timeline for filing the nomination papers and all those things. Is that clear? And which is covered under the provisions of Representation of People Act 1951. Because you already know 50 deals with all those things prior to the conduct of election. The actual conduct of elections, post conduct of elections is in 1951. Alright, so what is the answer in this case? Answer is option A. Which of the following is correct regarding entitlement to be registered as a voter in an electoral roll? So this is covered under which provision? The right to vote is guaranteed in the constitution itself, but however it is subject to what is called as the law that can be made by the parliament, because right to vote is not an absolute right. Even if you read the constitution, makes it very clear that every adult individual shall have the right to vote without any discrimination, subject to any law that is made by the parliament. So therefore further qualifications and exclusions can be done by whom? The law made by the parliament, which is provided under the Representation of People Act 1950. Therefore the correct expression of the right to vote is it's a constitutional legal right. All right. So if a question comes which gives only it is a constitutional right, it is saying fundamental right, constitutional right, then the most appropriate thing would be constitutional right. But even if they are not giving the constitutional right, but if they are mentioning it as a legal right without giving constitutional right, then you can choose that as well. All right. So the right is guaranteed by the constitution, but subject to the law that is made by the parliament. So these are all the. So what is the answer in this case? You might be knowing it. Any person must be a citizen of India, not less than 18 years of age, ordinarily resident in the constituency, and otherwise not disqualified by the law. So there are certain, these are all qualifications, but some disqualification are also given. Say for example, if they are unsound mind declared by a competent court, if they are found guilty of any of the electoral offences under the Representation of People Act, for time being in police custody. So these are all the grounds for their disqualification. So then if they are qualified by certain grounds, not disqualified by certain grounds, then their name can be registered in the electoral roll, which is there in the Representation of People Act. Very important, because the elections are also happening right now. So you may expect one question probably in the prelims. There are a lot of questions to come, so we will try to learn all those things. So most of the things, say for example, special intent derivation is something which is there in the current affairs also. So for which you should know at least the basics of special intent derivation. Now can anyone tell me the special intent derivation is provided under the representation of people Act 51 or 50? Is it 51 or 50? Now think it is with regard to the revising the electoral rolls, and electoral rolls are part of which act? It is Representation of People Act 1950. Is it clear to all of you? So first of all, it is Representation of People Act. I think to be very precise, section 21 of Representation of People Act 1950 talks about it. So what is the purpose of the special intent derivation? Its purpose is to ensure inclusion of all eligible citizens and exclusion of ineligible names from the electoral rolls. See, normally under the election laws in our country, before every elections they have to revise the electoral rolls. But despite that, if the Election Commission of India feels at any time they wanted to revise the electoral rolls, they can also do it under the provisions of what is called a special intensive revision. Especially when they feel that there are a lot of voters who are no longer alive, if they feel there is a lot of migration that has happened. So to make sure that the electoral roll is updated, who has authority to carry out the special intensive revision? The Election Commission of India. So first thing is anyways correct. It is linked with the electoral roll purification and transparency in the rolls. Is it clear? Yes, that is also true. It means that election already held becomes invalid unless a fresh SIR is completed. It has nothing to do with the election already held and all those things. This is just a distractor. It's just that any time if the Election Commission of India feels, they can do the SIR. But before the SIR, if the election result is already announced, you cannot just undo the election results because of the SIR has not been done. So this is not the right thing. Which of the statements given above are correct? It is 1 and 2 only. So when do you actually get the question paper? Just before the class or before itself? Just before the class. Okay. Which one of the following best reflects the legal effect on conviction under the election laws for a legislature or a candidate? So the conviction under the election laws is covered under which act of the Representation of People Act? 1951. It is one of the important grounds for disqualification. To be very specific, it is section 8 which talks about the disqualification on conviction for certain offences. In that also you might know that there is a general provision which talks about disqualification on conviction for offences where the conviction is minimum how much? 2 years. That is one general clause. But apart from that, it also says that the moment you are convicted on specific offences listed in the Representation of People Act, irrespective of the term of conviction, they are disqualified. In both the cases, automatic disqualification only. It does not require any specific order apart from the court conviction. But in one case, the conviction term has to be how much? Minimum 2 years. But in all the specific offences, the conviction term is not something which is specific. Even conviction, even if it is a fine, which is a conviction, that itself is sufficient enough. Okay, so with that, what is the answer? The 1951 law contains disqualification on the grounds of conviction, and conviction for specified offences can trigger disqualification from contesting or continuing as a member subject to statutory scheme. Now remember, this is very important, that this section 8 as a disqualification not only applies to someone who wanted to contest election, it also applies to whom? To an existing member of parliament. An existing member of parliament can also be disqualified. Anyone who wanted to contest election can also be disqualified from contesting election. Clear? This is very important for both your prelims as well as the mains examination. Which one of the following best describes the corrupt practices under the election law? Okay, now please tell me, the corrupt practice under the election law is defined or probably given in 51 or 50. It's broadly given in 51. So 51 gives a list of corrupt practices. So can you give me an example of corrupt practices? What are all seen as corrupt practices? No, untouchability is not directly. Untouchability, if they are convicted under the Untouchability Act, then they are automatically disqualified. The term of conviction is not important. But what is a corrupt practice? Very good. Bribing the voters, any undue influence, polarizing the people on the grounds of religion, race, caste, sex and all those things. So these are all considered views of government machinery in their favor. So these are all list of corrupt practices which is given in the Representation of People Act 1951. But tell me, the corrupt practices under the Representation of People Act 1951, is it a civil offence or a criminal offence as per the law? It's a civil or a criminal offence? It is not a criminal offence, it is only a civil offence. So therefore, can they be disqualified for corrupt practices? Because anyways in corrupt practices there can be no, even if conviction is there, they cannot be put to imprisonment. So one of the ground for disqualification is that the minimum imprisonment has to be how much? 2 years, but in this case it is not the criminal case. But however, even for corrupt practices they can be disqualified. But there is no automatic disqualification, try to understand, because it is not a criminal offence in itself. Also tell me who can declare a person to be guilty of corrupt practices. In case of MP or MLA or anyone wanted to contest election for MP or an MLA, who is authority to declare something? It is a High Court whose authority to declare something to be a corrupt practice. Once the High Court declares something to be a corrupt practice, based on the order or the judgment that is given by the High Court, now then the Election Commission of India will recommend the President or the Governors. So the disqualifying authority in case of the corrupt practice is whom? It is the President or the Governor respectively, depending upon who they are. And the disqualification go up to 6 years. That is also possible. Is it clear to all of you? But definitely corrupt practice is not a criminal offence in itself. Is that clear? This has to be very, very clear in your mind. And to be very specific, it is section 123 of the Representation of People Act 1951, which broadly describes as to what are the corrupt practices under the law. So based on this, what is the answer for this? They are specific prohibited electoral practices defined by the Representation of People Act by the 1951 law, and can affect the validity of an election as well as lead to disqualification of consequences. Okay. The only thing where they have not declared the election expenditure, that is the only case. Okay. Which one of the following is correct regarding the electoral offences under the election law? Now please tell me before I go to this particular question, is the electoral offences and the corrupt practices, are they one and the same? Because the word that is used in the law is corrupt practices or other election offences. Are they one and the same, or there are two different things? Okay, so we have already seen what is corrupt practices. You have given me some example. Can you give me some examples of what are considered to be election offences? Very good. Booth capturing is an other election offence. So for example, using pamphlets and conducting meetings and all those things after the silence period is over. Have you heard of what is a silence period? What is a silence period? That is, this is our 48 hours prior to the conclusion of the polling. It is not about the start of the polling. So normally the conclusion of the polling will happen in the evening of the day on which the polling happens. So prior to that 48 hours. So this time is what is called as a silence period. So during the silence period, somebody is conducting election meetings and all those things. That is basically an electoral offence. Booth capturing is an electoral offence. But remember, electoral offence is a criminal offence. It is not a civil offence, unlike the corrupt practices. Therefore, for the other electoral offences, there is no direct disqualification, but we know it is a criminal offence. So because it is a criminal offence, if their conviction on those criminal offences 2 years or more, then also they will be disqualified. Is that clear to all of you? Okay, anyways, which one of the following is correct regarding the electoral offences under the election law? So what is the answer? The election law framework also contains provision relating to electoral offences distinct from corrupt practices, because try to understand, corrupt practices are only a civil offence. And who is the disqualifying authority in case of corrupt practices? It is a President or the Governor respectively, but who is authority who can declare them to be convicted on corrupt practices? The High Court concerned, both in case of MPs and MLAs. But the ultimate disqualification will come from whom? The President and the Governor on the recommendation of ECI. But whereas in case of corrupt practices, if they are convicted, it is automatically considered to be a criminal offence, and if the punishment is 2 years or more, then they will automatically disqualify. Is that clear? So the answer here is option B. Consider the following statements regarding the postal ballot voting. 1. Postal ballot voting is recognized within the election law and the rules framework. Have you ever heard of postal ballot? So postal ballot is mostly used for the people in service. Usually people who are in the armed forces and certain other central services, probably that they may still retain their voting in some other constituency, but they may work on some other place. and also people may be on election duty sometimes, some other places. So, for those people there is a postal voting that is there. Service, so this is definitely true. Service electors are the important category for whom electronically transmitted postal ballot arrangement has been operationalized by the 𝐂𝐸I. Is it true? Yes, service voters are the major category, but I think recently the government has introduced this for the senior citizens also. But the major category of people still is the people in the service. Okay. Postal ballot means ordinary in-person voting at a polling station using EVM. So it is completely different. This is a normal voting. It is nowhere related to what is called as postal balloting. So which of the statements given above are correct? It is 1 and 2 only. Which one of the following statement is correct regarding the number of constituencies a person may contest in the general election or a group of by-elections? How many constituencies maximum as per the Representation of People Act? Presently it is only 2 constituencies. But suppose if a person gets elected in both the constituencies, then what is the case? He has to write it within how many days? Within 14 days. Within 14 days he has to write it to the speaker or to any other authority as the law may prescribe. Otherwise both the seats will become vacant. Okay. So what is the answer here? Which one of the following best reflect the statutory idea of disqualification for registration in an electoral roll? So basically we already seen that, but I already discussed the criteria. What are the criteria which the law provides for disqualification? If they are unsound mind, or if they are found guilty of any corrupt practices or other election offences, or also if they are in police custody at the time of the electoral roll being done. So these are all the grounds. So what is the answer here? The answer is option A. Which one of the following most accurate as per the election laws in India as of now? So just if you are having any issues, follow the elimination approaches also. So both approach you should follow. Special intensive revision is a judicial process conducted by high courts. No, it is a process which is carried out by the Election Commission of India. SIR has replaced the Representation of People Act. No, in fact the SIR is carried out under the Representation of People Act. We have already seen that. SIR is confirmed only on only to presidential election. No, nothing related to presidential election. It is related to what? It is related to the general election and also to the assembly elections they can do it. So both the cases. So the most appropriate thing is this one only based on the. So SIR is one area probably you may expect, but I don't think a very technical question, a general question. So general awareness should be there with regard to all these things. Alright, so please come to the next part. So some philosophical questions I have put. So this is again an important area. Which one of the following best captures the constitutional distinction between liberty and freedom? Which is the answer here? So and because we know the fundamental difference between liberty and freedom is what? Liberty is something which is always regulated by law. There will always be some reasonable constraints or restrictions, and freedom is something which is absolute in the absence of any external constraints, which is not good in a civilized society. So the answer is option A. Consider the following statements regarding the idea of justice in the Indian constitutional framework. Justice in the preamble includes social, economic and political justice. Yes. Justice is confirmed only to court procedures and punishments of wrongs. Is it true? So normally the word justice means justice in a court of law, but the idea of justice under the Constitution of India is not only that, it is social, economic and political justice. So this is not just limited to this idea. The constitutional vision of justice goes beyond formal equality and to seek transformation. That means we also focus on what is called as substantive equality. Have you heard of this? Formal equality means the idea is that everybody has to be treated equally. We just do not rely upon the principle of formal equality. We rather give a lot of importance to the idea of what is called as substantive equality, which means our real idea is that we will treat equally only when people are equally placed. So therefore, our constitution as a philosophy, as a principle also allows for what is called as discrimination, but not just discrimination, a positive discrimination in the form of various affirmative actions. So the constitution mission of justice goes beyond formal equality and seeks transmission. This is true. So what is the answer here? It is 1 and 3 1. Which one of the following best reflects the idea of rule of law? What is the idea of rule of law? Law is supreme over arbitrary power and all authorities are subject to the legal limits. That's basically there can be no arbitrary authority. That's basically what is called as rule of law. Which one of the following statement is most accurate about the democracy in the Indian constitutional context? So democracy is not only about regular elections or free and fair elections, but it is also a system where the institutions are accountable to the people. That is very, very important. So what is the most appropriate option? Answer is option D. Okay, so please look into the next question. I wanted answer from you. Which one of the following best distinguishes between a parliamentary system and a presidential system? What is the basic difference? The crux of the difference is the accountability of the executive to the legislature. In fact, during the debates in the Constituent Assembly, the parliamentary system was chosen because that is more accountable. Okay. So why do you think in USA, which is having one of the presidential system, which is a model presidential system, now why do you think that the president in United States of America is not as accountable as that of the prime minister in our country or the council of ministers in our country? He is not a, okay, he is not part of a legislature, is actually true, but that does not completely explain the answer. It is not giving the proper reason. So the survival of the president does not depend upon that his requirement to have the majority in the legislature, because the executive is completely independent of what is called as a legislature. But whereas in India, from where the executives come from? Legislature, and the survivability of the executives depend upon their ability to retain the majority. Alright, so that is a basic difference. So the answer here is what? Answer here is option A. So come to the next thing, consider the following statements. The UK system is based on parliamentary sovereignty. Is it true? What do you mean by parliamentary sovereignty? Parliament can make any law. There is no restriction except changing a man into a woman and a woman into a man. That is what the philosophical thought behind some of the thinkers who said that it is sovereign in the sense they can do anything, if at all the limitations that they have is only this. That is because of the fact that there is no written constitution, because any law that is passed by the British Parliament becomes part of their constitution. But whereas in India there is a constitutional supremacy, is there a limit to as to what kind of laws the parliament or the state legislature can make? Can you give me an example of what limitations are there? No, basic structure is not about the ordinary laws. Of course, that basic structure limit the kind of amendment that they can do to the constitution, but leave out the constitutional amendments. Is there any limitation upon what ordinary laws that can be passed by the parliament and the state legislature? Yes, because the laws cannot be violative of the fundamental rights. The limitation is there in the form of Article 13. So can the laws made by the parliament and state legislatures be struck down? Yes, if they are violative of the fundamental. So is there a limitation upon what laws can be made by the parliament and state legislature? Yes. So therefore there is lot of limitations, and which is supreme in our country is the constitution. That is why we say that we follow the principle of constitutional supremacy. In India, judicial review is stronger than the United Kingdom framework. Is it true? It goes without saying, because in UK any judicial review is largely restricted to the scope that they can only judicially review the executive action. They cannot review the laws itself, they cannot strike down a law itself, because once a law is passed by the British Parliament, it is their constitution. The judiciary cannot question the constitution. The judiciary can see whether the executives have implemented that law properly or not. But in India, can the judiciary question the law also and also the executive action also? Yes. So therefore our judicial review is much broader in scope and stronger than that of United Kingdom. These are all important conceptual areas where UPSC can ask you as a question. Okay. So what is the answer in this case? So all the three are correct. Answer is option B. So which one of the following captures the meaning of constitutionalism? So limited government. So which is the most appropriate thing? Option C. Which one of the following best reflects Indian secularism as compared to a stricter Western separation model? So what is the difference? So what is the answer? So, the basic difference is that we follow a positive secularism, that means we are not against any religion, and also the state does not identify itself with any religion, or it does not treat different religion differently. But the same model is there for the Western countries also, but the difference is basically in India we followed interventionist model. In the state can intervene in the matters of religion, but that is not the case in the Western countries. So, anyways, the proper answer here is option B. Which one of the following most accurately accurate regarding the separation of powers? Please give me an answer. Accurate regarding the separation of powers. India follows a functional separation of powers with overlap. Do we have an overlap? So, separation of powers means every organ should be separate, but we do not have clear separation, but a functional separation of powers, because there is a overlap between which organs? Executive and the legislature, but the constitution still distributes the core powers among the legislature and executive, which only means it is saying though we follow the principle of separation of powers, there is no clear separation of powers, though there is an overlap, but still we have proper checks and balances in possession. Consider the following statements regarding the checks and balances. The judicial review is a check on the legislative and executive action. Yes, true. Collective responsibility is a check with parliamentary government. Collective responsibility is a check with parliamentary government. Is it true? Yes. Where the legislature is having control over the executive. Legislative oversight through questions, motions and committees act as a check on the executive. Yes. So, all the things are different ways of check upon the other organs. So, what is the answer here? 1, 2 and 3 only. So, what about the president not giving assent to the aid and advice of the council of ministers? Is it part of checks and balances? Some of the, say probably some certain instance the president can exercise a veto power. Under certain circumstances he can do that. So, can that be seen as a part of checks and balances? How many of you think that it is part of checks and balances? Suppose if the president not giving assent to the bills, that is definitely not part of checks and balances. Okay. Why it is not part of checks and balances? Checks and balances means one organ over the other organ. So, if it is within the same organ, it is not part of the checks and balances. Is it clear to all of you? You will have to see in which way the questions are coming. If it is the same organ, it is never the idea of checks and balances, but if it is a different organ, then you can say it to be part of checks and balances. That is okay, that is what the question, that is why I said how the language is there. If they say that the council of ministers advise, so basically if he is going against the council of ministers, that is part of, not part of checks and balances. If he is doing over against the will of the parliament, because the president is not to go against the will of the parliament, he acts only on the aid and advice of the council of ministers. So, for the president, what is done by the legislature does not matter, because he is just a normal executive who is acting on the aid and advice of the council of ministers. So, between the council of ministers and the president, then it is not the case. Say, reconsidering the bill, yes, if you are sending it to the legislature, you can think it, okay. Who? The president is part of the legislature, but it does not mean that he is a representing a legislative body. That is for the reason that we have already told. It is because of the reason that he has to summon the legislature and all those things. But predominantly, he is considered to be the head of the union executive. He represents the executive branch. Okay. So, what is the next question? Which one of the following best reflects the nature of Indian federalism? So, that is a quite easy question, but sometimes I can ask you questions. I think we have questions on that similar fashion also, which UPSC does mostly ask us. They can give you a list of things, ask you to identify which of the following are federal features and which are unitary feature, for which irrespective of whatever you read, that is not going to help you unless until you have an understanding of whether it is a federal or an unitary feature, which is a quite easy question. So, try to practically see if you have any doubt, and you will have to definitely attempt such questions. Okay. Which one of the following best explain judicial review? What is the answer? Judicial review means the power exercised by the judiciary over whom? Other two organs of the state, that is the legislature and the executive. That is basically what is called as judicial review. What do you mean by review powers of the courts? So basically don't get confused if these words are coming in the examination. Judicial review is not equivalent to review powers. Judicial review is a power of the judiciary to review the actions of other two organs. Review power is a power of the judiciary to look into own actions, that is its own judgment. That is basically review powers. Can anyone tell me which article in the Constitution allows for review powers to the Supreme Court? Article 137 of the Constitution. Though it is not explicitly given, the same article was interpreted by the Supreme Court to give curative powers also. Review powers is directly given, but the Supreme Court said that Article 137 also gives what is called as curative powers, which can be filed on top of a review petition. Does the High Courts have review powers on a similar footing with that of the Supreme Court? Why it is not on a similar footing? Very good. While the review powers of the Supreme Court flows from the Constitution, for the High Courts, the review powers are acquired from the ordinary laws of the land. Is that clear? So, what is the answer for this question? Option B. Which of the following features that supports the independence of judiciary in India? Security of tenure of judges, removed by difficult constitutional process, salaries charged on the consolidated fund. Yes. So, what is the answer here? All the three. The process of removal of judges is very important. Okay, it was in the current affairs, so it is very important. Which one of the following best explains the basic structure doctrine? Parliament may amend any part of the Constitution, but cannot destroy the damage the essential features. That means, to put it in a very simple way, the amending powers of the Parliament is not unlimited. It is limited where they cannot take away the basic structure in the Constitution. Which of the following best reflects the constitutional role of civil services in relation to law and liberty? So, what is the role of civil services? Policy implementation. That is a major thing within the broader framework of law. That is what is their major role. Okay. So, do not think that civil service means that they have to formulate the policies, although there is a lot of role to policy formulation, but majorly as per the constitutional framework and the idea of the civil services, they are the implementing authority. They have to implement the policies. That is a major function. Okay, now we are going to some of the miscellaneous topics under the Constitution, and then finally I will touch upon some current affairs topics in this also, and the next 100 questions also I will touch upon. But now from now on we are going to touch upon some miscellaneous areas. So, if you see whatever you have seen till this point of time, they are the concrete areas. 70 to 80% of the questions are likely to come from these areas also, subject to if UPSC is suddenly changing the pattern that we are not able to, that shock everybody has to take in case. But in a subject like polity, it is very unlikely to happen, because polity, at least for the prelims, if you see that they have to ask it from the Constitution and the basics that they have to ask it. So, what are the topics we have covered? Right from, if you see, we have touched upon the preamble, we have covered union and its territories, we have covered citizenship, we have covered the fundamental rights, DPSP, fundamental duties, basic structure doctrine is also covered, executives we have covered, legislature we have covered, judiciary we have covered, center state relations we have covered, local bodies we have covered, constitutional bodies we have covered, and then we also covered the representation of people act and the philosophical themes. So, even if you revise these things, most of the things will be covered. It's just that you will have to go and apply these things when you go to the examination. A few things out of this may also come, but largely if you are prepared, you are in a position to answer these things. But from now on, there are a lot of miscellaneous articles which UPSC may pick. So, I have focused upon those miscellaneous topics. We will do that. Okay. So, come to the next question. Which one of the following best describes the constitutional protection given to certain agrarian reform laws from challenge under the fundamental rights? So, basically, okay. So, what is the answer? Can you tell me? It protects the specific categories of laws such as acquisition of estates and matters, related matters from invalidation on the grounds of contravention of certain fundamental rights. So, basically, does anyone know which article it is referring to? It is largely referring to article 31A. So, when you talk of agrarian reforms and all those things, it is largely referring to article 31A. Although I understand that article 31B also provides a protection, but not in the same manner. Article 31B by virtue of the 9th schedule in the Constitution. And Article 31C is not just to agrarian reforms, it is to protect Article 39B and Article 39C. Therefore, if a question comes on agrarian reforms largely, it is by virtue of Article 31A. So, what is the protection that is given under Article 31A? Certain categories of laws. If the objective is to enact certain categories of laws, there are 5 categories of laws. If the objective is to make these laws, and these laws cannot be challenged in a court of law on the grounds of violation of which articles? 14 and Article 19. That is what you will have to remember. But however, try to understand, to get this protection that the law not to be challenged on the grounds of Article 14 and Article 19, this law, if it is passed by a state legislature, let us assume the parliament makes a law, that is a different thing. If the state legislature makes a law, then this law has to be reserved by the governor for the consideration of the president, and who has to give the assent to the bill? The president has to give the assent to the bill. Okay, that is something that you have to remember. All right. So, anyways, the answer in this case is option B. Which of the following is correct regarding Article 31B? Article 31B is providing for what? 9th schedule. Article 31B was inserted when? By the first Constitutional Amendment Act in 1951. 9th schedule was inserted. So, what is the scope of Article 31B? So, the scope of Article 31B is provides for the 9th schedule, and if any law is placed inside the 9th schedule, now try to understand, then that is subject to what is that is immune from what is called as judicial review. Although today it is not completely immune from judicial review, it can still be challenged on the grounds of violation of basic structure that forms part of the fundamental rights. Okay. So, what is the answer here? It is linked to a constitutional device that protects specified acts and regulations placed in the 9th schedule against judicial review, subject to some exceptions. Answer the following statements regarding the constitutional protection linked to the policy of the state under Article 39B and Article 39C. It protects laws giving effect to the policy of the state towards securing the principles of Article 39B and Article 39C. That means, is there a constitutional dimension such? So, which article is giving this protection under the constitution? Article 31C, but that framework is there. Okay, so this is definitely true. It is originally covered only Article 39B and Article 39C. Is that case? It originally covered means when this Article 31C was brought in. Can anyone tell me? Very good. 25th Constitutional Amendment Act 1971. It is not talking original constitution. It is saying originally whenever this provision was brought in, was this provision protecting only Article 39B and Article 39C? Yes, it was protecting only Article 39B and Article 39C. So, that is definitely true. The attempt to expand it to all the directive principles came through 42nd Constitutional Amendment Act. Was it true? Is that true? So, what has been done by the 42nd Constitutional Amendment Act is originally Article 31C was brought in by the 25th Constitutional Amendment Act 1971. When it was originally brought in by the 25th Constitutional Amendment Act 1971, Article 31C was protecting the laws giving effect to only Article 39B and Article 39C over Article 14 and Article 19. But then thereafter the 42nd Constitutional Amendment Act gave this protection to Article 39B and Article 39C over the entire directive principles of state policy. So, that attempt was made, but however that amendment to that extent was nullified in the Minerva Mills case. So, therefore, there was definitely an attempt. Is the statement correct? Yes, this particular statement is also correct. So, what is the answer here? It is option C. Which one of the following best reflect the present constitutional status of right to property in India? It is a constitutional legal right. Why I am saying it is a constitutional legal right? Is it guaranteed in the constitution? Which article does it? 300A. So, guaranteed in the constitution, but definitely not part of the fundamental rights. But why it is a constitutional legal right? So, though it is guaranteed in the constitution, it can be executed only by a way of a law. A law is required. If at all the right to property is to be deprived, the constitution says it has to be done in accordance with the law. Therefore, without a law you cannot give execution to this and take away the property. So, therefore, the law is required. So, therefore, the most appropriate thing is it is a constitutional legal right. So, in the examination again if they give a constitutional right you can select it, no issue, but without constitutional right if they are giving legal right then also it is correct. And one more thing that you have to keep in your mind, this right is not only available to the citizen, it is available to the aliens as well. Therefore, basically it is available to any person. Is that clear? So, what is answer? Answer. Which one of the following best describes the constitutional scheme relating to recruitment and conditions of service of a person serving in the union or the state? The appropriate legislature may regulate the recruitment and conditions of service law. Until then, the president or the governor make rules. Are you sure that this is correct? Because it is the longest statement. Now, why it is correct? So, you cannot apply the same trick to all the questions. You will have to tell me someone who is telling that it is correct, because it may not be correct also. If you are telling it is correct, why it is correct? Because the idea of solving any question is not just to identify the answer, but to understand the logic behind it. Because if you just identify the answer, it is not going to help you in the UPSC examination. Therefore, even if you make mistakes, that is good, as long as you are understanding why you have made the mistake, so that you are not going to repeat it in the examination. No issues. But can you tell me where, how do you say this is the right thing? It logically may appear to be correct also. That's okay, but what is the source? Is it there in the constitution? Is it there in any law? I am trying to locate that. If you are confidently saying this is the answer, probably you should know that this is there in the constitution, or this is coming from so and so law in our country. What is the position is what I am trying to ask, because it describes a constitutional scheme. So, therefore, is it there in the constitution? Yes. Which article? No, not article 3 and 2, but near to that. 3.1? 317? No. No. You have to come below. This? No. Article 309. It is article 309 of the constitution which provides for this particular constitutional framework. Alright, so article 309 of the constitution makes it very clear that the service condition shall be determined by the respective legislature. Till then, the respective executive heads can make the rules. Alright. So, for example, today the Parliament has enacted the All India Services Act for the All India Service people. They have enacted Central Civil Services Act. Similarly, various state government has enacted their State Civil Services Act. So, it is based on that, it is all protected. Very, very important. So, this is a miscellaneous area, but yes, questions can come earlier, though 25 years and all those things, UPSC has asked such questions. Which one of the following best captures the doctrine of pleasure in the Indian constitutional framework under article 310? Though this doctrine of pleasure is used in number of articles, it is also used in article 310 of the constitution. So, what best reflects the idea of doctrine of pleasure under article 310? So, can anyone tell me what best reflects? What is the answer? The member of defense services and civil services of the union or the state, all India service holders, civil post, hold office during the pleasure of the president or the governor, subject to constitutional. That is right, but can anyone tell me what is this doctrine of pleasure? Doctrine of pleasure is saying that the president or the governor can remove them at any time. That is basically what is called as doctrine of pleasure. So, the doctrine of pleasure means that all the central government officials or probably the defense officials over, they all hold office during the pleasure of whom? President. Similarly, the state government officials hold the office during the pleasure of whom? Governor. So, does it mean that tomorrow the president, if he wants, he can remove any all India service official at his will? So, this article 310 which talks about the doctrine of pleasure also makes a reference that it is subject, it has to be read along with article 311 of the constitution. So, yes, by the language of article 310, that all the officials hold office during the pleasure of the president and the governor, but it cannot be read alone. It has to be read along with the provisions of Article 311. It is Article 311 of the Constitution that provides a protection to the All India service officials or the central government officials or the state government officials. What is the protection that is given under Article 311 of the Constitution? It is saying that it is definitely true that all these officials hold office during the pleasure of the respective executives, but it is also saying that while exercising the pleasure, they have to recognize what is given, protection given under Article 311. Two protections are given under Article 311 of the Constitution. The first protection is that no person can be removed from their service by any subordinate authority to the appointing authority. Therefore, if the president is appointing authority, no other subordinate authority can remove them, which means if the president is issuing the appointment by a warrant under his hand and seal, that means who is the removal authority also? For all the All India services, though the president is appointing authority, but the appointment is not coming from a warrant under his hand and seal. So therefore, he may delegate that appointment to some of the other authorities. So whoever is appointing authority which the president has allowed as per the transaction of business rules, only that authority or an authority above that is the removing authority. Alright. So no person below the appointing authority can remove the person from the service. That's the first protection. Second protection is even that authority who has authority to remove cannot do so without giving a reasonable opportunity for that particular person. That means a fair inquiry has to be conducted. Only after the fair inquiry is conducted and based on the finding on that inquiry, then only they can be removed from the service. So both the conditions has to be followed. Is that clear? Subject to these two conditions, then the pleasure will apply. Then after this, then yes, on your will that they can remove. Is that clear? But however, Article 311 also provides for some exceptions. It is not that in all the cases an inquiry has to be done. It is not in all the cases that it has to be done only by the appointing authority. Some exceptions are there that even without the inquiry they can do it. So that also we will see. So Article 311 provides for such exceptions as well. So what is the answer in case of Article 350? Sorry, question 356. It is option B. Okay, so consider the following statements regarding the constitutional protection to the civil servants. Basically, under Article 311, a civil servant cannot be dismissed by an authority subordinate to which he was appointed. Is it true? Yes. A reasonable opportunity of being heard is part of the protection against dismissal, removal, or reduction in the rank. Is it true? Yes. In certain exceptional situations, enquiry may be dispensed with. Is it true? Yes. So only in exceptional cases which is given in the Constitution itself. So for this, the answer is all the three. But now let us see what are the exceptions. Just try to apply your logic. What could be the exception? Just see it. No, read the question properly. Which one of the following is not one of the constitutional exceptions? That means what could be a reasonable exception? Suppose if the conviction on a criminal charge, already the court has made an inquiry, the court has found him guilty. So is it make sense that not to have a separate inquiry before taking an action? So that could be an exception. Serious criminal charge is there. It is not reasonably practical to hold an inquiry. That means the possibility of holding an inquiry may not be possible on certain issues, maybe related to security or some other issues. So then also okay. Security of the state makes, this is again a lot of discretion, it gives a lot of discretion, but this is given in the Constitution. Security of the state or makes inquiry inexpedient, that is the security of the state may be at compromise. Can there be a valid reason? The last thing is mere administrative inconvenience. That means some officer have to be put at inconvenient to do that inquiry and all those things. That cannot be a valid ground, that the Constitution allows for it. Okay. So what is the answer here? It is option D. That is, the inconvenience of the government cannot take away the principle of natural justice of an individual. Alright. Which of the following correctly states the constitutional process of creating an all India service? Here this is very important article. The relevant article is Article 312. So here two things that you will have to understand. All India service can be created by whom? Only the Parliament, not the Rajya Sabha. Rajya Sabha has no authority to create all India service. Who is authority to create the all India service? Parliament. But the Parliament cannot pass a bill, create an all India services unless and until the Rajya Sabha initiate the process. So, who has to initiate the process? Rajya Sabha by passing a resolution by a special majority to create a new All India service. And what is the majority by which this resolution has to be passed? Not less than 2/3 of the members present and voting. But Rajya Sabha passing a resolution does not mean that the Rajya Sabha has already approved the bill. Rajya Sabha is only giving the permission to introduce the bill, and then further it can be introduced in any of the houses. Then it has to go through all the process like an ordinary bill, and then it has to be passed and get the assent of the president. Then a new All India service can be created. Now, why do you think that this protection is given to the Rajya Sabha before creating an All India service? Because any new All India service is created, it has an impact upon the federal structure of our constitution. So, therefore, All India service, is it a federal feature or it is a unitary feature? It is a unitary feature. It has an impact upon the federal structure. Therefore, the states have to give their consent, which is represented through Rajya Sabha. All right. So, what is the answer in this case? The answer is option A. Which of the? In fact, none of the All India service is mentioned in the constitution. Are they directly mentioned? Are you sure? Please have a look into it. Article 3. No, please have a look into it. It's mentioned. And is there a reference of All India Judicial Service also? In which context? We'll have to see in which context. Can anyone give me the book? Just give me a. Where is Article 312 starting here? Pusa here. Just give me. Okay, what is your question? Hmm. 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 No, if they say that which of the services are mentioned, All India services are mentioned in the constitution, then the forest service of course will not be there, because forest service is not mentioned here. But how many All India services are there? Because there is no need to mention an All India service in the constitution, because anyways who has authority to create All India service? Parliament by a law. The only way that they wanted to give a reference to the Indian administrative service and police services, both the service already existed even during the British India. So they are just giving a reference of saying that these services are deemed to be created by an act of parliament. And also the Constituent Assembly at that time, probably they had an idea of creating probably one more service, All India Judicial Service. So therefore they have given a reference of All India Judicial Service. If at all, if it is created, the rank will be equivalent to that of so and so judicial authority. So therefore whatever is mentioned is only these three things, although in existence only two services out of this are there. And in addition to that, though the All India service, the forest service is not mentioned, it is also an All India service. So if they ask you how many All India services are there, without giving any reference to the constitution, 3 All India services. But how many All India services are mentioned among whatever All India service we have? It is only these 2 All India services. Okay. But separately, if they ask, is there a mention of All India Judicial Service? Though we do not have such a service, but if they just ask, is there a mention of All India Judicial Service? That is also mentioned. Okay. Which one of the following best captures the constitutional idea behind the provisions concerning the claims of scheduled caste and scheduled tribes in the services? There is a specific article which is telling that the interest of the scheduled caste and scheduled tribe has to be taken care when it comes to the representation in the public services, but subject to certain condition. That is, again UPSC has asked it number of times, even before 2 years this was asked in UPSC examination. So, which article is that which takes care of the interest of the scheduled caste and scheduled? It is article 335. So, they said that there should be adequate representation of the scheduled caste and the scheduled tribe in the government services, but without compromising on the administrative efficiency. So, the government has to find out a way to ensure the representation of the scheduled caste and scheduled tribe in the government services, but at the same time not at the cost of what? Administrative efficiency. Is that clear? In fact, this is the very basis of Nagaraj case, which is talking about the reservation in promotions. Anyways, right now you just remember this, that is article 335. So, what is the answer? It is option B. Okay, so please try to match these two things. Tell me the answer. Scheduled caste, scheduled tribe, socially and educationally backward classes. Yesterday also we have discussed this. It's just a different way that the same area has been asked as a question. What is the answer? A is the answer. Can you also tell me the relevant articles? 341 for whom? Very good. For the scheduled caste, it is article 341. For the scheduled tribes, it is article 342. Very good. And then socially and educationally backward classes. Very good. Article 342A, again inserted by which amendment? Very good. 102nd Constitutional Amendment Act, but again subsequently amended by the and what is the reason for the second amendment? They specifically restored the powers of the states to have their own backward list. Okay, very good. Which one of the following is correct regarding the official language of the Union? What is the official language of the Union in the Constitution? Hindi in Devanagari script. But however, for the first 15 years, the Constitution itself permitted English also to continue, subject to the law made by the Parliament. But this can be altered by whom? The law made by the Parliament. But otherwise, if the law has not been made by the Parliament after 15 years after the commencement of the Constitution, Hindi in Devanagari script should be only the official language of India. But presently, in addition to Hindi, what is also the official language? English, because the parliamentary law has allowed for it. The Official Languages Act has allowed for it. 1963 it was passed. But in the Constitution, what is the official language? Hindi in Devanagari script. For the first 15 years, English also. But in the given thing, what is the answer? Hindi in Devanagari script. Which one of the following best reflects the constitutional position regarding the official language of the states? Now remember, while for the Union, the official language is given in the Constitution itself, subject to the law that can be made by the Parliament. But for the states, the Constitution does not prescribe any official, and this is even more important, that this is not a one-time power of the state legislature. That means the state legislature, if they want, they can keep changing or adding their official languages. Is that clear? So what is the answer here? The answer is A. What about the official language between the Union and the states? The Constitution makes it very simple. The official language between the Union and the state is the official language of the Union. Whatever is official language of the Union will be the official language between the Union and the states. Therefore, the official language between the Union and the states can be Hindi or it can be English also. So, normally what is being followed is, if the state also has a Hindi as their official language, Hindi can be used as an official language. But if the state is using any of the other official language, so naturally which will be the official language? It will be English. Is that clear? But in addition to that, between the states they are talking about, so between the Union and the state is always what is called as the official language of the Union. Between the states, so the states, if they have a common language, they can provide for that also. Otherwise, English would continue to be the official language. So what is the answer here? Which question are we discussing? 364. So the right answer here is the language authorized by the Union, or the states can also agree upon their own languages. Which one of the following reflects the constitutional protection given to the president and the governors? There is a special immunity which is given to the president and the governors under Article 361, very important. Article 361, the scheduled tribes and the scheduled caste, special provisions, the Article 335, these are all the areas you can expect 1-2 question, where the students sometimes may miss out, okay. So, just have a clarity on all these areas. What is the answer here? They are not answerable to any court or exercise of performance of powers or duties of their office, okay. So, they cannot be questioned, they cannot directly be questioned, but can their actions be questioned in a court of law? Does that immunity is also there under Article 361? See, there are two things. One is the president being called upon for their action. The second is that the action has been carried out in the name of the president or the governor, but can those actions be questioned in a court of law? They can be questioned in a court of law, but who cannot be summoned? The president and the governors cannot be summoned. Consider the following, a follow-up of that, consider the following statements regarding the constitutional immunity to the president and the governors, again Article 361. No criminal proceedings whatsoever shall be instituted or continued against them during their term of office. Is it clear? Yes. No process for arrest or imprisonment shall issue during their term of office. Yes, that is not possible. Civil proceedings may be instituted against them in every case with 3 months of prior notice. It is 2 months of prior notice. Yes, civil cases can be there, but the notice time is how much? 2 months of prior notice. So, therefore, this is wrong. So, what is the answer? It is 1 and 2 only. So, which one of the following best reflects the constitutional amending power after the 24th amendment? What is this 24th amendment? Very important. Some important amendments I have picked, so that the possibility is that sometimes they can ask you why this 24th amendment is very of a huge significance in the among the amendments in our constitution. Because the 24th amendment is the one which enabled again the parliament to make amendment to the constitution. So, if you remember the basic structure doctrine, in the 𝐂𝐭 case, they said that the parliament will not be in a position to amend the fundamental rights. For the reason they said that Article 368 does not give them any constituent power to amend the constitution, because the word power is nowhere mentioned in Article 368. So, which was reversed by making an amendment to Article 368. So, they inserted the word powers and procedure to amend the constitution. So, this is a very important amendment, but in addition to that they also made one more change in Article 13, if you can recollect the same amendment. What is the law, sorry, what is the change that they made in Article 13? So, they said a constitutional amendment is not a law under Article 13. Is that clear? So, both the changes has been brought in. So, what is the answer in this case? Parliament may, in exercise of its constituent power, may add, vary. That means they also have given unlimited powers for the constitution, for the parliament to amend the constitution. Which one of the following amendment is most closely associated with placing the election of certain high constitutional authorities beyond the ordinary judicial challenge, a step that later struck down judicially? 39th? Yes, it is a 39th Constitutional Amendment Act. Already once UPSC asked this question. 39th Constitutional Amendment related to what? Can you recollect? No, which case? I am just asking if you. Very good. It is the Raj Narayan case, where the election of the president, vice president, prime minister and the speaker, all their election was kept beyond the scope of judicial review, but subsequently it was struck down by the Supreme Court. Okay. They say that the Supreme Court has no authority to hear this case because they were challenging the election. After the case has become sub judice, in the meantime the amendment was made. Within 4 or 5 days the amendment was made. Next hearing they argued the Supreme Court has no authority to look into this particular matter because the constitution stands changed now. But the Supreme Court said that, well, that statement is true as long as it remains in the constitution, and then they have struck down that provision, saying that it is violative of the basic structure in the constitution. Which one of the following best describes the broad constitutional effect of the 44th Amendment on right to property? So, what is the answer? It removed the right to property from Part 3 and relocated as part of the constitutional legal right, which is Article 300A. So, therefore, we call that as such. Consider the following statements regarding the 42nd Constitutional Amendment Act. It attempted to expand the protection under the provisions linked to the directive principles beyond Article 39B and Article 39C. Does it intended to expand the scope of Article 39B and C, the protection given beyond 39B and C to the entire DPSP? Yes. It is associated with very wide constitutional changes across several parts of the constitution. It is also called as a mini constitution. So, yes, it inserted the 9th schedule into the constitution. It was by the first Constitutional Amendment Act. Okay, so that is not the case. So, what is the answer here? It is 1 and 2 only. Which of the following is correct regarding the first amendment in relation to the judicial review and land reforms? It is associated with the inserting of saving provisions from certain laws in the 9th schedule. Okay. So, this again a very simple question, but many times UPSC has asked this 9th schedule, first Constitutional Amendment Act. So, very simple question, sometimes may come again. Okay. 84th Amendment is very important. One topic which I foresee is one way or the other, there may be a question from the 84th Constitutional Amendment Act, delimitation and all those things. There are a lot of questions that I kept in delimitation. We already solved some, but the questions are likely to come. Which one of the following best reflects the change connected with the 84th Amendment? That it extended the freeze on readjustment of seats until the first census after 2026. So, before this, what was the arrangement? That the freeze was till year 2000, which was done by which amendment? 42nd. Otherwise, what is the original position in the constitution? Not every 10 years, after every census. Although the census happens every 10 years, but it may happen, may not happen. There is no constitutional requirement that the census has to happen every 10 years. The constitution says that after every census, there is a need for delimitation based on the latest census. Okay. But that has been now subsequently shifted. Okay. So, what is the answer for this? It is answer. Which one of the following is the best match? So, among the things, what is the best match? 6th schedule is wrong, 7th schedule is also wrong, 8th schedule is also wrong. So, the answer is 5th schedule. So, we will see some of the questions on the schedule, because probably you can expect one question from the schedules also. Which one of the following best describes the 10th schedule? It is related to the anti-defection law. And when was this anti-defection law brought in and the 10th schedule was brought in? 52nd Constitutional Amendment Act in 1985. So, what is the answer? Which one? You want me to repeat? It's repeated. Which question? This is left. Okay, solve it. What is the answer? 6th schedule is not related to allocation of seats. 7th schedule is not related to the languages. 8th schedule is not related to legislative subjects. So, what is obviously the answer? 9th schedule. Which one of the following best describes the 6th schedule? It deals with the scheduled areas generally where the all India under the same pattern as the 5th schedule. It deals with the administration of tribal areas, which also allows for creation of autonomous districts or regional or autonomous regions. So, the answer is option B. Does the PESA Act apply in the Schedule 6 areas? The PESA applies in which areas? Schedule 5 areas. So, the PESA Act has been brought in because already we have seen when we are doing the local bodies, the provisions of the 73rd and 74th Constitutional Amendment Act may not apply throughout the territory of India, especially the Panchayat area does not apply to the Schedule 6 and Schedule 5 areas. It may also apply to the union territories with such modifications. Because it does not apply to the Schedule 5 areas, there is a need for a separate local body which was brought in by way of a parliamentary law, that is a PES Act. But what about the Schedule 6? In Schedule 6 we are also saying that the local body provision does not apply, the PES Act also does not apply. So who will carry out the local administration there? It is done by the autonomous, which is done by the autonomous districts or also the autonomous regional councils. Okay, so they do all those things. In fact, this is a very powerful body because we have seen that they exercise not only the administrative powers, they also have certain legislative as well as judicial powers. Which one of the following best reflects the 7th schedule? The different list which is given in the constitution. What is the relevant article? What is the source of schedule 6? Sorry, schedule 7. Very good. Article 246 in the constitution. Which one of the following best reflects the 8th schedule? The languages given in the constitution. But remember, there are few amendments that has happened. 3 amendments are at least related to that: 21st, 71 and 92. If you add these two things, you will get 92. But also do remember what are all the different languages added by different amendments. Sometimes it's a very factual thing, but UPSC may sometime ask, please make today only go and make a note of all those things as to which language was added, what was originally there, then what was added subsequently. So all those things can also be sometimes asked. Consider the following statements regarding the constitutional amendment procedure. Some amendments require special majority of the parliament alone. Yes. Some amendments additionally require ratification by not less than half of the state legislature. Yes. Federal provisions form the class requiring state ratification. Is it true? Yes. All the 3 things are true. So what is the answer? 1, 2 and 3. Which one of the following is most accurate regarding the president rule in a constitutional amendment bill? So what is the role here? Based on the question, what is the best answer? Can he return it for reconsideration? Can he exercise absolute veto? He may keep pending it indefinitely as a packet veto? No, because explicitly what is given in the constitution is that he has to give the assent. But among the given thing, after that it is presented to the president, and after which what the president has to do? Probably he has to give the assent to that, which was mandated by which amendment? By the 24th Constitutional Amendment Act 1971. Okay. Which one of the following best reflects the present constitutional position on the scheduled caste list? The president specifies them by public notification for state and union territory subject to the amending powers of the parliament. I think almost the same question. What is the answer? B. Come to the next question. Which one of the following is not correctly matched? Which is not correctly matched? 10th schedule. It is not correctly matched. Okay, so can anyone give me the answer for this? Which of the following are correctly associated? First Amendment, 24th Amendment, 42nd Amendment, 44th Amendment, 84th Amendment. First Amendment, insertion of protective savings provisions and 9th schedule. Yes. 24th Amendment, strengthening Parliament constituent power under amending procedure. 42nd Amendment, amendment to widen the shield linked to DPSP. 44th Amendment, changes in right to property. 84th Amendment, extension of the freeze linked to the readjustment till after 2026. Yes. So all the things are correctly matched. So the answer is, it is option B. Sorry, what is the answer? Sorry, D is the answer, all the things. Okay. Which one of the following constitutional amendment is most likely directly associated with the insertion of anti-defection law? Which one? This is the 52nd Constitutional Amendment Act. Okay, the Constitution 130th Amendment Bill 2025 seeks to provide for the removal of Prime Minister, the Chief Minister, the Ministers in which one of the following circumstances? What is the major provision of this law? If any of these person is arrested and detained for 30 consecutive days for an offence punishable with 5 years or more, then probably that the office has to be vacated. But there was a lot of opposition to this particular bill, and this bill, what is the status of this bill right now? It has been referred to the Joint Parliamentary Committee for the broader study. Okay, it may not get passed because it also requires a constitutional amendment to do all those things. But remember 130th Constitutional Amendment Bill, but recently they have introduced 131st Constitutional Amendment Bill. What is that related to? It is only related to the delimitation. So, delimitation in the sense that to implement the women's reservation, earlier the delimitation is based on the first census post 2026. Now, that has been done away in this particular bill, and they may apply it with the 2011 census, alright. But anyways, that bill is also already defeated. In case if they ask this was related to what? It was related to largely the delimitation. So, what is the answer in this case? Answer is option. Consider the following statements regarding the Constitution 131st Amendment Bill 2026. It proposes to increase the maximum strength of Lok Sabha from 550 to 850. Yes, there was a proposal to increase it. It retains the requirement that the reservation related delimitation must be, reservation here means women reservation related delimitation must be based on the first census after the commencement of 2023, commencement of 2023 women reservation law. Is it correct? Because they have done away with the need for the first census post 2026, rather they have taken into account 2011. Anyways, that is no longer the, anyways this bill has already been defeated unless until the government again introduce it, but this is the provision when they introduced it. Which of the following statements are correct? It is one only. Consider the following statements regarding the appointment of the Chief Election Commissioner and the other election commissioners. The Constitution itself lays down a detailed appointment procedure for CEC and the election commissioners. The Constitution does not provide for it. It is only the Constitution enables the Parliament to do that. Alright. So, that the law was recently made. The 2023 law provides for a search committee headed by the Cabinet Secretary. In fact, if you see, don't get confused. In fact, if you see, the law allows for two types of committees. One is a search committee, another is a select committee. So, what we have been discussing a lot of time is only the select committee, it is not the search committee. The search committee will identify a panel of officers. So, if suppose there are 3 officers who are to be appointed, they may recommend name of 5 to 6 officers. That is the role of the search committee, which is headed by the Cabinet Secretary. Thereupon, among the names suggested by the search committee, the select committee will select the names and then recommend for the appointment to the President. And that select committee is the one which will be headed by the Prime Minister and then the leader of opposition and any other Union Cabinet Minister as per the law. But you should also know what was proposed by the Supreme Court. What was proposed by the Supreme Court? Instead of a Union Cabinet Minister, it was a Chief Justice of India. So, all the things are clear. So, therefore, coming back to the question, the Constitution itself lays down detailed appointment procedure for the CEC and EC, that is wrong. The 2023 law provides for search committee headed by the Cabinet Secretary. Is that true? Yes. Do not confuse between the search committee and the select committee. Is that clear? So, what is the answer in this case? It is 2. And this is again important. Recently, I think there was a report in the name of what is called as Panchayati Raj Devolution Induction Report 2024, which was published, which basically assessed the functioning of Panchayati Raj in various states, and this rating was based on certain parameters. Okay. So, can you give me what is the parameters that they would have focused upon? Based majorly on these 3 parameters, that is functions, funds and functionaries. What is this functions, funds and functionaries are related to? Functions means to what extent they are empowered with powers. Funds means how much financial devolution is given. Functionaries means not only powers and functions, to what extent they are having the manpower, human resource to carry out such things. Because today if you see, most of the local bodies, and the local bodies do not have their own separate cadre of officers. They are all under the control of whom? The state government. Therefore, the local elected leaders may not have any control over these offices. The same issue that the states might have with regard to the all India service with the center, the same issue is that the local body is having with regard to whom? To the state government, because these officers are under the control of whom? The state government. So therefore, functionaries, do they have or not, do they have the control over, do they have sufficient manpower is another issue. So it is based on all the three things. Answer the following statements regarding the Finance Commission, because this is a very simple question, but in the next question paper that I will discuss, I went some current based the 16th Finance Commission, which I think we already discussed in the class also, but anyways, this is again a very important area. Finance Commission, because of the 16th Finance Commission report, becomes very important this year. Answer the following statements regarding the Finance Commission of India. The Finance Commission is constituted under Article 280 of the Constitution. Yes. The recommendation of the 15th Finance Commission covered a period up to 31st March 2026. Is it true? Yes. 1st April 2026 for the next 5 years, I think 31st March 2031, the 16th Finance Commission report will be implemented. So, what is correct? So, I have given at least 4-5 type of questions in delimitation. You can expect one from the Finance Commission, one from delimitation, one from removal of various authorities, the 130th Amendment, 131st Amendment, the Panchayat Developmental Index. These are all very important current affairs areas. Okay. Answer the following statements regarding the delimitation in India. As per the Constitution, the next readjustment to the Lok Sabha seats is based on the first census conducted after 2026. Is it true? The question is as per the Constitution. So, is it correct? Where it is amended, only the bill is introduced. What it is saying? As per the Constitution, the next readjustment to the Lok Sabha seats is based on the first census conducted after 2026. That is what is the provision based on the 84th Constitutional Amendment Act. But don't get confused with the 131st Constitutional Amendment Bill, which proposed 2011 census. That is merely a bill. That bill has also been defeated. So, you will have to see whether the question is as per the amendment bill or as per the Constitution. That is what I am trying to say. So, as per the Constitution, even today it is definitely true. The controversy over the delimitation arises partly because such readjustment may alter the relative representation of states in the Lok Sabha and the states. Is it true? Will it affect the representation both in the Lok Sabha as well as in the legislative assemblies if the delimitation is done? Yes, it will affect that also if they change the census. Which of the statements given above are correct? Both one. With reference to the emergency provisions in the Constitution, consider the following pass. So, what is the answer here? This is again a significance because there are a lot of articles, 50 years of national emergency after the 1975. Last year there was a lot of articles. So, some provisions which may be related to the emergency provisions can be asked, especially national emergency. Okay. So, what is the answer? All three or whatever it is. All three. Which one of the following correctly describes the constitutional requirement of removal of speaker in Lok Sabha? For the reason recently there was a removal motion that was attempted against the speaker of Lok Sabha, becomes very important. Okay. So, what is the answer? Removal by a resolution of the House passed by majority of all the then members of the House with after giving him a 14 days of notice. This is what is the exact expression given in the Constitution, but sometimes they may also use what is called as effective majority. Privilege Committee, again very important current affairs topic. The Committee on Privileges examines the cases of breach of privileges referred to it. Parliamentary privileges is concerned only with the financial powers of the Parliament. That is a wrong statement. So, therefore, what is the answer? A is correct and R is wrong. Okay, so option A is the correct answer. Supplementary, additional and excess grants are provided under which of the following articles? Article 115. So recently, I think last year election of vice president has also happened. So therefore, the election of vice president also is a current affairs topic, but in these areas only conventional areas will be asked, though it is in the current affairs. Consider the following statements regarding the election of vice president in India. The electoral college consists of members of both houses of parliament, including nominated members. Yes, only the members of parliament, both elected and nominated. The election is held in accordance with proportional representation by means of single transfer vote. Yes. What is the answer? Both 1 and 2. UPSC was established originally 1926. The Government of India Act 1919 provided for this, but it was established on 1st of October 1926. 100 years of UPSC. So it was reported in the newspaper. So therefore, you should be aware of this. Okay. So at that time, it was called as Central Public Service Commission, but then later it was renamed as Federal Public Service Commission in the Government of India Act 1935. At the commencement of the constitution, then thereupon it was called as Union Public Service Commission. Is that clear? Very important, simple question, but they can ask you, okay, from the current affairs. So initially 1926 it was called as Central Public Service Commission, renamed as Federal Public Service Commission after the Government of India Act 1935. At the commencement of the constitution, it is Union Public Service Commission. Answer the following statements regarding the Estimates Committee of the Parliament. It consists of only the members of Lok Sabha. Ministers are not eligible to be a member. Yes. It examines the budget estimates and suggests economies in public expenditure. Yes. Which of the statements given above are correct? Consider the following statement. The Supreme Court of India has recognized the right against the adverse effect of climate change as implied under Article 21. These are all some current developments. The Supreme Court in 2026, I think a month back or something, few months back, the Supreme Court in 2026 recognized dignified menstrual health as a part of Article 21. Is it true? Yes. So sometimes such current developments may be asked. Okay. So what is the answer? Both 1 and 2. Consider the following statements regarding NALSA and free legal aid. NALSA was constituted under the Legal Services Authority Act 1987. Yes, which is the highest authority, the nodal authority for the implementation of the Legal Services Act. One of NALSA's core function is to organize Lok Adalat. There are 2-3 important objectives of the Legal Services Act. One is to provide free legal aid to the necessary people, that is the poor people, and then to also to provide the Lok Adalats, alternative dispute resolution, to provide legal awareness as the other objective. So one NALSA's core objective is to organize Lok Adalat. Definitely, it is a form of an ADR. Every person in custody is excluded from free legal aid under section 12 of the Act. Then it defeats the very purpose. So not every person will be given the free legal aid, but every person who may be a poor may be given the free legal aid under the NALSA, okay, under this Act. So therefore, this is wrong. Which of the statements given above are correct? 1 and 2. Alright, so now we will go to the next set of questions. So whatever separately I wanted to cover, I have already covered it. So now some current affairs topics will be there in addition to what we already discussed, and also some important areas from again largely from the constitution. So we will complete that as well. Shall I move forward? Okay. So come to the next set of questions. Personality rights are explicitly defined in a single comprehensive law in India. Today, a lot of celebrities have gone to the court protecting their personalities or personality rights. So what do you mean by this personality rights, which is in the current affairs only? So basically, because of the use of AI and technology, so now there is deep fake videos using their voice, using their images. So they are trying to protect all those things, which is also used for commercial purpose. So this is basically protecting, this is basically what is called as the personality rights. So personality rights are explicitly defined in a single comprehensive law in India. Is it true? We do not have a comprehensive law in this. So therefore, that is wrong. The courts in India have recognized personality rights as a part of right to privacy. Is it true? some of the high courts have already recognized. So therefore, the statement is true, although this matter has not come to the Supreme Court under conclusive decision, because this is just the beginning of all these issues. But definitely sooner or later some authoritative judgment will come from the Supreme Court. But yes, already I think the Bombay High Court and certain other high courts, Delhi High Court, they have recognized it to be part of right to privacy. So what is the answer? This is true. So which of the statements given above are correct? It is 2 only. Consider the following statements regarding the 16th Finance Commission. It retained the 41% vertical devolution. Yes. It introduced contribution to GDP as a new factor in the horizontal distribution. Is it true? Yes. It increased the weight to tax effort in the formula. In fact, the tax effort has been removed, which is different from that of the previous 15th Finance Commission. So remember what are the criteria in the 16th Finance Commission, what has been added, what is a change in the weightage, all these things becomes very important. Okay. So what is the answer? It is 1 and 2. With reference to the Committee on Privileges, consider the following. So in the last class itself I discussed Committee on Privileges, what type of committee? It is an inquiry committee, but largely it is considered to be an administrative committee. The role is, function is inquiry, but it is part of the administrative committees. So most of the administrative committees are both in the Lok Sabha as well as Rajya Sabha. Okay, so they will have a separate privilege committee in the Lok Sabha, separate privilege committee in the Rajya Sabha. So come to the Lok Sabha committee on privileges may have 15 members, is it true? And Rajya Sabha 10 members. In fact, this is true to most of the administrative committees. Okay, the members are elected by the House, the members are nominated. Okay, so there is no election with regard to these committees. So what is the answer? It is 1 and 2 only. Which of the following best distinguishes due process of law from the procedure established by law? Which is the one best distinguishes between them? The due process of law allows a court to examine the fairness, justness and the reasonableness of the law, which may not be the case, which is not the case in the procedure established by law. Therefore, what is the ultimate end because of this difference? Both the executive and the legislative actions are subject to judicial review. Okay. Answer the following statements. Delimitation is mandated after every census under Article 82. Is it true? Yes. The current freeze on delimitation is applicable till 2026. Delimitation affects only the Lok Sabha constituencies. It may affect the legislative assembly constituencies as well. So which of the statements given above are correct? 1 and 2. Consider the following statements regarding the national emergency of 1975 to 1977. It was declared under Article 352 of the Constitution on the ground of internal disturbance. Is it true? Yes. So, but presently what are the grounds on which the emergency can be proclaimed? It is on the grounds of war, external aggression or armed rebellion. So, but at that time it was internal disturbance. Fundamental right under Article 19 were automatically suspended during emergency. Yes. See, this Article 19 that the fundamental right is automatically suspended is a provision under Article 358. So, at that time it can be automatically suspended, but subsequent to 44th Constitutional Amendment Act, they said it can be only on external grounds, but that time that restriction was not there. Okay. Because the question is asking, consider the following statements regarding the national emergency of 1975. It has to be seen in reference to 1975. The 44th Constitutional Amendment Act replaced internal disturbance with armed rebellion as a ground for emergency. Yes. So this is because of the 50 years of national emergency. So that was also there in the news. Okay. So some kind of question, or they can directly ask you some conventional questions from these areas also. So what is the answer? It is answer option D. With reference to the cabinet system, consider the following statements. Cabinet is a smaller inner body within Council of Ministers. Yes. All ministers in the Council of Ministers are part of cabinet? No. Cabinet is a chief policy formulating body in the parliamentary executive case. And is there a mention of the word cabinet in the constitution? Yes. Which is the only place where there is a mention? 352. So what is the answer here? It is 1 and 3. Which one of the following is the most essential feature of democracy? Accountability of the government to the people. That is the single most defining thing. Which of the following has been derived by judicial interpretation from Article 21 of the Constitution? So among the given, what is the answer? Right to be protected against the effect of climate change. Which of the following are prohibited by the Constitution under the right against exploitation? All? Sure. Think about it, which is coming from both Article 23 and Article 24. So traffic in human being, beggar, and also child labor. So because it's not specifically asking for any specific article, it is right against exploitation. So entire theme you should think. Okay. So what is the answer here? It is option C. Under the Constitution of India, freedom of religion includes freedom of conscience and the right to profess, practice and propagate a religion of one's choice. Just to only the broader principles, just to revise those things. With reference to Article 13, consider the following statements. Laws inconsistent with the fundamental rights are void to the extent of such inconsistency. Is it true? Article 13 includes ordinance within the meaning of law. Is it true? What are the things which are included within the meaning of law under Article 13? Ordinary laws, ordinance, bylaws and other executive orders, and also customs which is having a force of law. So everything is included within that. So therefore ordinance is definitely there. Every constitutional amendment is automatically treated as a law under Article 13. What is excluded? Constitutional amendment is excluded, which was not there in the original constitution. Initially it was only a judicial interpretation, but which amendment explicitly excluded that? 24th Constitutional Amendment Act 1971. So every constitutional amendment is automatically included as a law is a wrong thing. So what is the answer here? Which of the statements given above are correct? Yes, option A, 1 and 2. Which of the following is the correct essence of right to equality? Equality permits reasonable classification but forbids what is class legislation. Alright, so yes. Which of the following freedom is not guaranteed under Article 19 clause 1? So which is not there in Article 19 clause 1? Freedom of life and personal liberty. Basically you should know the 6 rights under this, which is not there is right to freedom of life and liberty. Consider the following statements regarding the cultural and educational rights under part 3 of the Constitution. Any section of citizens having a distinct language, script or culture has the right to conserve it. Is it true? See here, if you see in the last 100 question that I am doing right now, there may not be much emphasis on the articles. It will be more emphasis on what is called as the concepts, and UPSC questions will be like this. Earlier whatever you have done is only for the purpose of covering more grounds, but now it is more similar to that of UPSC questions. So if you are very comfortable, more or less your conceptual clarity is there. Okay. So consider the following statements regarding the cultural and educational rights of under part 3 of the Constitution. Any section of citizens having distinct language, script and culture has the right to conserve it. Is it true? Yes. Only religious minorities can establish and administer educational institutions of their choice. It is religious as well as linguistic minorities. The state cannot discriminate in granting aid to educational institutions on the ground as they are under minority management. Is it true? The state cannot discriminate in granting aid. So the state cannot discriminate in granting aid to the minority education institutions as well. Okay. If at all the state comes out with a policy of giving aid, the minority education institutions will also receive the aid. So what is the answer? It is 1 and 3 only. Which one of the following correctly distinguishes between habeas corpus and mandamus? What is the difference? Habeas corpus is issued against illegal detention. Mandamus commands performance of public duty. Very good. Why are directive principles of DPSP are said to be non-justiciable? What is the reason? The courts cannot compel the government for implementation. It is only to implement the DPSP directly. But already if a law is there which does provide a legal right, they have to implement that, they have to honor that. With reference to fundamental duties, which of the following statements are correct? They were originally part of the constitution as adopted in 1950. No. They are enforceable by courts in the same way as fundamental rights. One of the duties is to develop scientific temper, humanism and spirit of inquiry. Yes. So what is the answer? It is only 3 only. Which of the, with reference to the size of the council of ministers at the union level, which of the following is correct? What is the answer? 15. It shall not be less than 15% of the strength of the Lok Sabha. But however, what it is in case of the states? What is in case of states? There is no 10. There also it is 15% is maximum, but minimum there has to be 12 ministers. Is that clear? That 10 is only for certain union territories. Alright. In case of what? In case of Delhi and Jammu and Kashmir, it is 10 as per the provisions of the law. But whereas in case of Puducherry, it will be determined by a presidential order. So please do not confuse. In case of states also, it is 15, but subject to minimum how much? 12 ministers. So what is the answer here? It is 10%, not minimum, maximum. It is all only maximum. In case of union government, the maximum number of ministers is 15% of the strength of the Lok Sabha. Clear? It cannot be more than that. It can be minimum less than that. No issues. The only maximum limit is there. Similarly, in case of the states, there is a maximum limit, but they also kept a minimum. So the maximum is 15%, but minimum it shall not be less than 12 ministers. But it is not necessarily they have to reach the maximum limit. They cannot breach the maximum limit, but minimum there has to be 12. That is for the reason there are some of the states which has got only 32 MLAs. There are some of the states which has got 40 MLAs. There are some of the states which has got 60 MLAs. So 60 MLAs means 15% of that will be how much? 9 MLAs, and 9 ministers may not be able to do with all the ministries and departments. So therefore, minimum 12 you have, subject to the maximum of 15. In case of Delhi, maximum is 10%. But if they chose less than 10% also, it's okay. But maximum is how much? 10%. Same is the case with Jammu and Kashmir. In case of Union Territory of Delhi, Union Territory of Puducherry, the president may decide by an order. Okay. Consider the following. Article 77 deals with the conduct of business of the union government. Yes, which is related to the transaction of business of the union government. Article 78 lays down the duties of the Prime Minister. Yes. Article 78 empowers the President to promulgate ordinance. Article 78 empowers the President to promulgate. No, it is Article 123. So this is wrong. So what is the answer here? It is 1 and 2 only. Which of the following correctly describes the Attorney General of India? He is the highest law officer of India. Yes. Which I think we already covered the other dimensions. A governor may reserve the bill passed by the state legislature for the consideration of the president. Which of the following is a most accurate statement? When in case the governor reserves a bill for the consideration of the president, the governor can reserve only money bills. Can the governor reserve the money bills? Can he reserve the money bills? In fact, it is a discretionary power of the governor to reserve any bill, including the money bill. What he cannot do with regard to the money bill is only he cannot send it for reconsideration. Is that clear? So what it is asking? Which of the things is the most accurate statement? The governor can reserve only money bill is wrong. The governor has the role, governor has no role once a bill is passed by the state legislature. Then he is the one who has to reserve it. So anyways, that is not the right thing. Certain bills may be reserved when the constitution so requires or when the governor deems it necessary. That means in certain condition it is mandatory, in all other cases it is a discretionary power of the governor. Therefore, the right expression is option C. So in which case it becomes mandatory? High court power is affected. In all other cases it is a discretionary power. But remember, once a bill is reserved by the governor for the consideration of the president, then there is no role of the governor. Who will decide the fate of that particular bill? It is only the president, then thereupon will decide the fate of the bill. So what are the options in the hands of the president once a bill is reserved? He can give the assent, he can withhold the assent, and he can send it for reconsideration provided the bill is not a money bill. So in case of money bill, he cannot send it for reconsideration, and otherwise he can send it for reconsideration, and he can send it for reconsideration as many times. There is no restriction on that. Question number which one? 423. Which one of the following statements regarding the governor of a state is correct? The governor is elected? No. The governor has a guaranteed tenure of 5 years? No. The governor is appointed by the president and holds office during the pleasure of the president. Is the pleasure of the president in this regard subject to judicial review? Yes. It is subject to only judicial review. The Supreme Court has never said limited judicial review. They use this word limited judicial review only in the context of pardoning powers. So here they said it is subject to judicial review. Does anyone know in which case I have said? In BP single case, not in SR Bombay case. BP single case in 2010 they have told it. Anyways, case is not very important, but it is subject to judicial review on the grounds of mala-fide intention. Consider the following statements regarding the immunities of the president and the governors. They are not answerable to any court. Is it true? Yes, just now you have seen. Criminal proceedings cannot be instituted. Civil proceedings in respect of acts done in personal capacity can be instituted during a term only after giving a notice of 6 months. What is the case? It is 2 months. So what is the answer? 1 and 2. Which one of the following most closely associated with the discretionary power of the governor? Reserving the bill for the consideration of the president. Can he summon the state legislature on his own? That is on the aid and advice of the Council of Ministers. Appointing judges of the High Court, he has no role. The constitution has said that, but presently it is all the collegium. Passing the state budget without the Council of Ministers, no, that is the role of the entire legislature. Okay, so he has nothing to do on that, except that he may deliver a speech in that session. So otherwise, nothing is his role. The President of India can grant pardon in which of the following cases? Punishment by court martial, offences against laws relating to union executive powers, death sentence. Yes, very good. So in all the 3 cases, he can do it. Which of the following forms part of the electoral college of the election of the president? So among this, what is the correct answer? Elected members of both the house of the parliament and the elected members of the legislative assemblies of the state. So among the given option, this is right, but it does not exclusively say everything, but this is the most appropriate option. Which one of the following method is used for the election of the president? Proportional representation by means of single transfer vote, and the voting is a secret ballot. In fact, the same method is followed for the Rajya Sabha elections also, with only one change. What is that? There it is open ballot, here it is secret ballot. In fact, there the open ballot is not given in the constitution. So the principle of election is given subject to the law that is made by the parliament. That open ballot comes from the Representation of People Act 1951. Okay, but here secret ballot is given in the constitution itself. But in both the cases, there is one similarity also. Anyways, anti-defection law cannot apply in the presidential election because they will not come to know. But whereas in the Rajya Sabha elections, can they come to know if there is a cross voting? Yes, because it's an open ballot system. But can the anti-defection law apply? The anti-defection law cannot apply. With reference to the ordinance making power of the president, which of the following statement is correct? What is correct with regard to the ordinance making power? An ordinance has the same force and effect as an act of parliament, subject to the parliamentary approval later. So within how much time the parliament has to give the approval? Within a period of 6 weeks after both the houses of the parliament comes into session. If they do not come into session at the same time, it will start from the later house which came into session. Okay. Which one of the following correctly describes the Advocate General of the states? He is appointed by the governor and is the highest law officer of the state. Yes. Answer the following statements regarding the members of parliament. A person must be a citizen of India to become a member of parliament. The minimum age requirement in case of Rajya Sabha is 30 years. Disqualification on the grounds of defection is decided by the president. Is it true? On the grounds of defection is always by the presiding officer. Very, very important area. And under the constitution, except for anti-defection, in all the cases it is a president and governors for the members of the state legislature. But under the Representation of People Act, there are certain automatic disqualification. In one case by the Election Commission, in other cases it is again by the president and the governors. Clear? What is the main purpose of delimitation? Among the given thing, redraw the boundaries. But delimitation does not only mean redrawing the boundaries. It is also about deciding the number of seats and then redrawing the boundaries, and then upon preserving some constituencies also. Okay. But given thing, the major thing is redrawing the boundaries. With reference to summoning and the prorogation of the parliament, consider the following statements. The president summons each houses of the parliament from time to time. Yes. So what is the only thing he has to keep in mind? That there is no lapse of 6 months. Okay. So 6 months shall not intervene. This is true. Prorogation ends the life of Lok Sabha. No, only the dissolution of the house will end the life of the Lok Sabha, not the prorogation. And similarly, prorogation will not have any effect upon the bills that is there pending in the houses as well. Okay. That's again a very important area. On top of that, UPSC has also asked that there are fixed number of sessions in a given year, fixed number of days they have to sit, names of these sessions are given in the constitution. None of these things are in the constitution. The only thing what is in the constitution, that there shall not be a lapse of 6 months. Okay. Prorogation ends a life is not the right thing. What is the answer? 1 and 2 only. The Speaker of the Lok Sabha may be removed from office by a resolution passed by a special majority in both the houses. Is it true? Yes. Sorry. The Speaker of the Lok Sabha is removed by what? A resolution passed by, okay, sorry, it is option A. A resolution passed by a simple majority of all, so that is wrong. Some mistake is there. So it is a resolution passed by a majority of all the then members in the Lok Sabha. Okay. So the right answer is option A. Okay, so this is a very important thing. Consider the following statements regarding the Deputy Speaker of the Lok Sabha. He is elected by the Lok Sabha from among its members. Yes, we know that there should be a member of that house. He remains in office even after the dissolution of Lok Sabha until the next Lok Sabha meets. This is the case only for the Speaker. There is no such provision for the Deputy Speaker. Is that clear? So therefore, this is wrong. He is subordinate to the Speaker in the sense that he cannot preside over the house. Is it true? He is subordinate to the Speaker in the sense that he cannot preside over the house is a wrong thing. He is not a subordinate to the Speaker. Okay. So the Speaker cannot give any direction to the Deputy Speaker, and in fact when the Deputy Speaker is presiding over the house, he will have all the powers as that of a Speaker. So what is the answer here? It is 1 only. The chairman of Rajya Sabha is a Vice President of India. Which one of the following statement is correct regarding the Secretariat of Parliament? Both Lok Sabha and Rajya Sabha can have a separate Secretariat staff. Is it true? Is the Constitution allows for it? Yes, the Constitution itself allows for having a separate Secretariat. but who will determine their service conditions and all those things? The parliament by a law will have to do it. Until then, the president can make the rules. Is it clear? Parliamentary privileges are intended to primarily ensure the independent and effective functioning of the legislature. That means they should not be afraid of criticizing the government or making the government accountable. So, independent does not mean that without any checks and balances, because you also understand that even the parliamentary privileges are subject to what? Subject to the rules and the provisions in the constitution, and the parliamentary privileges is only within the house, it is not outside the house. Which one of the following correctly distinguishes a money bill and a financial bill? So, money bill, we know that it comes from which article? 110 is where it defines it, but even a money bill falls under the larger constitutional category of financial bill. It is also a financial bill, part of financial bill, but we are calling that as a money bill only for the purpose it is having a subject matter little different, and also procedure it is little different. Which article deals with the procedure of a money bill? Article 109 of the constitution. And which article deals with the financial bills? 117, where we know how the financial bills can be further classified as finance bill type 1 and finance bill type 2. Okay, so what is the answer in this case? A money bill deals only with the matters listed in article 110, while a financial bill, which means here when you are talking about a financial bill, we are excluding the money bill. A financial bill which may include those matters along with other matters. So, that is true especially in case of a financial bill type 1. But what about a finance bill type 2? It does not contain any of the matters. So, largely this definition is restricting between a money bill and a finance bill type 1. Is it clear? But anyways, what is the most appropriate thing here? The answer is option B. So, can anyone tell me what is the subject matter of finance bill type 2? It first of all, it does not involve any of the matters in article 110, and thereupon it also involves what? Expenditure from the consolidated fund of India. With reference to a constitutional amendment bill, which of the statement is correct? What is the answer? It can be introduced in either house of parliament. So, it is saying the money bill deals with the matters which is mentioned in article 110, and then it is saying a financial bill may include those matters along with other matters. That means it is largely defining a finance bill type 1. 440 option B. Your question is related to 439 or 440? What is the doubt in 440? With regard to a constitutional amendment bill, anyways it does not, the option itself is wrong, that is just a distractor. There is no such thing in the constitution, it is just a distractor. Okay. So, what is the answer here? It can be introduced in either houses of the parliament. In no case the prior recommend, that is completely wrong. Okay. It is not wrong because of all cases, it is wrong because of the prior recommendation itself. Okay. Which of the following is correct regarding question hour in parliament? It is meant to enable the members to seek information. Okay. No conference motion can be introduced only in the Lok Sabha, and what is the article relevant to this? Article 75 is closely related to this, where the Council of Ministers are collectively accountable to the Lok Sabha. 75. Article 74 is talking about the aid and advice of the Council of Ministers. It is 75 which is talking about the collective responsibility. Consider the following statements. Departmentally related standing committees examine demand for grants of ministries. Is it true? Yes. Public Accounts Committee examines appropriation accounts on the CAG reports. Yes. Estimates Committee contain members from both Lok Sabha and Rajya Sabha. So among the 3 financial committees, it is only the estimates committee which has got membership only from where? Only from the Lok Sabha. And what is the membership? In case of public accounts committee and committee on public sector undertaking, 22, and further bifurcation, 15 from Lok Sabha and 7 from Rajya Sabha. In all the cases, all the 3 financial committees, the members are elected. Is that clear? They are elected by a system of proportional representation. Clear? So what is the answer in this case? Which of the statements given above are correct? Is it is 1 and 2 1. A legislative council of a state can be created or abolished by what? Parliament by a law after the legislative assembly passes a resolution by special majority. What is a special majority in this case? Both the conditions. It has to satisfy both the conditions. In case an ordinary bill passed by the state legislative assembly, the legislative council may delay it maximum period of. So total it is 4 months. So can an ordinary bill be rejected by the legislative council once it is passed from the assembly? Yes, they can reject it. Among the options, one of the options they can reject it also. Which of the following statements correctly reflects the relation between the power of Lok Sabha and Rajya Sabha? Lok Sabha is more powerful in financial matters and in control over the executives. Can you give me an example of how it is more powerful in financial matters? Money bills, demand for grants. So all these things are only the prerogative of whom? It is only the Lok Sabha. And with regard to control over executives, no conference motion. That is most importantly, no conference motion. Which one of the following is exclusive power of Rajya Sabha? 2 important things that you have to remember. One is Article 249 and other is Article 312. These 2 things are exclusive powers of the Rajya Sabha. So what is Article 249? Parliament is empowered to make a law on item in the state list, provided who passes a resolution? Rajya Sabha. Okay. And Article 312, all India services. Again, in both the cases, the similarities in both the cases, the special majority is also same. Just only one condition, not less than 2/3 of the members present and voting. So what is the answer here? C. With reference to the contempt powers of the Supreme Court, which article is talking about the contempt powers? Article 129. Article 129. In case of high courts, very good, 215. The Supreme Court is court of record. As a court of record, it has a power to punish for its contempt. This power is derived only from the ordinary law made by the Parliament. The power is derived from the Constitution itself. It is only the ordinary law supplements the power that it is given. It further defines, prescribes punishment and all those things. But otherwise also the power is coming from where? From the Constitution, that is under Article 129. So therefore, to say it is derived from the ordinary law is completely wrong. So which of the statements given above are correct? It is 1 and 2 1. Which of the following correctly distinguishes ad hoc judges and retired judges of the Supreme Court? An ad hoc judge is appointed from the High Court judges. So who can be appointed as an ad hoc judge? Only a High Court judge who is eligible to be appointed as a Supreme Court judge, not anybody who is eligible to be appointed as a judge of a Supreme Court. Okay. Whereas a retired judge or a former judge is requested to sit and act as a judges of the Supreme Court. This is correct, but try to answer further questions. Now, in case of an ad hoc judge, who makes the appointment of an ad hoc judge? Chief Justice of India. Who will request a retired judge in Supreme Court? CJI. So, in which case it requires a prior consent of the President? In both the cases. In which case it requires a prior consent of the concerned judge as well? Only in case of retired judge. Is that clear? So, the answer is, in this case, is option B. The power of judicial review means it is power of the judiciary to review the actions of the other 2 organs. The doctrine of basic structure means Parliament can amend the constitution but not alter the basic structure. Consider the following regarding the appointment of judges in the Supreme Court. The judges of the Supreme Court are appointed by the President. The Constitution explicitly mentions the collegium system. The collegium system has evolved through judicial interpretations. So what is the answer? It is 1 and 3 only. The original jurisdiction of the Supreme Court primarily covers dispute between, it can be between union and state, it can be between state versus state, it can be between union and some of the states on the other side and some of the states on the other side. Can it be between an union and the union territory? No. That is not a federal dispute. Can it be between a union territory and a state? Then it is like a dispute between union and a state. Very important area. Which article talks about the original jurisdiction? Very good. Article 131 of the Constitution. With reference to the advisory jurisdiction of the Supreme Court, what is the answer? The President may refer questions of law or fact. Can he refer a matter of fact as well? Yes, fact of public importance to the Supreme Court for its opinion, but it is not binding upon the Supreme Court to give its opinion, but there is a small thing that you have to understand. If any opinion is with regard to pre-constitutional matter, binding for the Supreme Court, post-constitutional matter, not binding. Alright, and also in either of the cases, in both of these cases, the opinion given is not binding upon the President. Okay. And what is the relevant article? It is Article 143 of the Constitution. Answer the following statements regarding the High Courts. There shall be a High Court for each state. Yes. The Parliament may establish common High Courts for 2 or more states. Yes, every High Court is a court of record. Yes, there is no doubt in that. Every High Court is a court of record under Article 215 of the Constitution. Which of the following statements given above are correct? All the 3 are correct. Who has authority to create a separate High Court for a union territory? Who has? Parliament or President? So that to say, whatever you think first is always correct. It is a Parliament. The President has no such authority. And similarly, who has authority to expand the power of a High Court, jurisdiction of High Court over a union territory? It is again the Parliament. It is only the Parliament. The authority to expand the jurisdiction of a particular High Court to a union territory. It is Parliament. Only the articles are different. Okay. So, but it is the, I don't want you to burden with the articles. If you remember, you remember, but I don't want you to do that. But at least remember who can do that. Okay. It is the, we already discussed. If you have already noted it down, you can revise it. But again, not very important. Okay. Which of the following is correct regarding the officers and servants of the Supreme Court? So, what is the answer? The Chief Justice of India has an important role regarding the appointment and service conditions subject to the law. Okay. And remember, all these officers are recruited either by the Chief Justice or by any of the other judge or an officer as decided by the Chief Justice of India, and their salaries, allowances, all those things are charged upon the Consolidated Fund of India. Okay. So, the same will be for the officers and servants of the High Court, where there will be Chief Justice of the concerned High Court. Which one of the following best reflects the extraordinary power of the Supreme Court? What is extraordinary power of the Supreme Court? They can pass orders to ensure complete justice, even if those orders go beyond the ordinary law of the land. The only court in our country which has got this extraordinary power is the Supreme Court. Even the High Courts do not have this power. Is that clear? And here you can remember the article because questions have come from the articles also. Article 142 of the Constitution. So, what is the answer here? Sorry. Which one of the following best describe federalism? What is the answer? Division of powers between the different levels of government. Okay. It has nothing to do with the different organs of the state. Whenever the question is related to the different organs of the state, it is talking about the principle of separation of powers within largely the different levels of government. So, it is morely related to what is called as division of powers, although there is also division of powers with regard to what is legislative powers also, but it is more what is called as vertical in nature. Okay. So, that is what you will have to understand. So, what is the answer here? Answer is option B. Consider the following situations in which a parliament can legislate on a matter in the state list. What are the grounds? If the Rajya Sabha passes a resolution, during the proclamation of national emergency, if 2 or more states consent for such legislation, to implement international treaties of importance, yes. In all the 4 cases it can be done. The answer is option 1, 2, 3 and 4. So, UPSC will largely focus on such areas. UPSC may not ask you to remember the exact article and all those things, but 1 or 2 questions may come. Okay. So, for that purpose I am just discussing the articles, but if your larger understanding is right, easily you can get 80% of the questions right. Maybe more than that also, just on a conservative side I am doing it. But if the clarity is not there, it may be less than that also. That is, it is not guaranteed that it will you will always get 80%. So, which of the following are generally regarded as the federal features of the Indian Constitution? Division of powers between union and states, written constitution, independent judiciary, single citizenship. No, single citizenship is not a federal feature. Okay. It is more an unitary feature. So, except for that it is all federal features. So, this kind of question UPSC does ask. Okay. With reference to the administrative relation between the center and the states, which of the following statement is correct? What is the right answer here? The union may give direction to the state in certain matters to ensure compliance with the parliamentary laws and national interest. Is that clear? That is a general principle that defines their administrative relationship. So, broadly it is covering the scope of both Article 256 and Article 257. Which one of the following best reflects the financial relation between the center and the states in India? So, which is reflecting the constitution provides for distribution of tax revenue between the union and the states. Which one of the following best describe Gram Sabha? It is A. So, these things I think we already discussed in some question earlier. Consider the following states regarding the reservation of seats in Panchayat. We have done this also. Okay, I'll just, what is the answer but quickly? All the 3 are correct, I think. Okay, who conducts election to the local bodies? State Election Commission. Who appoints the State Election Commissioner? Who removes the State Election? It is the President, because the State Election Commissioner is removed in the same manner as that of Judge of a High Court, which is equivalent to that again the Supreme Court Judge. Which one of the following best reflects the constitutional position regarding the powers and responsibilities of the Panchayats? The powers and responsibilities may be endowed by the state legislature with respect to the preparation of plans and implementation. So, it is all to be decided by whom? The respective state legislature. Answer the following regarding the District Planning Committee and Metropolitan Planning Committee. The District Planning Committee consolidates a plan prepared for Panchayat and municipalities in the district. Is it true? Yes. So, do not make the mistake that it will prepare the plan only for the municipalities. For the entire district it will prepare, which may contain both the Panchayat as well as the municipal area. The Metropolitan is meant for a metropolitan area. Both District and Metropolitan Planning Committee are constitutional bodies. Yes, it is directly allowed to be established in the constitution. Only their membership and how they function and all those things, the law may be made by the state, but otherwise it is directly established by the constitution. 1, 2 and 3 only. So, mandatory and voluntary provision I think will be in a position to identify. The question may little vary, but I am sure that largely the voluntary provision is with regard to their powers and functions. With regard to reservation, with regard to the periodic elections, with regard to the structure, these are all mandatory provisions. So, here the answer is option C. The Comptroller and Auditor General can be removed in the same manner as that of Judge of a Supreme Court. And who is authority to remove the Judge of a Supreme Court? President, based on the motion passed by the Parliament. And what is the ground on which a judge misbehavior and incapacity? The same ground on which the CAG can also be removed. Answer the following thing regarding the Chief Election Commissioner and other election commissioners. They are appointed by the President of India. Their appointment is now governed by a parliamentary law. Yes. The constitution is itself originally laid down detailed collegium style of appointment mechanism. No, it has left just to the President. Now tell me that what is the difference between a select committee and a search committee? Who gets a select committee? for the appointment of the election commissioner? Search committee is basically a first level committee. Select committee is the highest committee which will decide the exact members to be appointed. Search committee is by the cabinet secretary. Select committee is headed by the prime minister. So what is the answer in this case? It is 1 and 2, that is option A. Yes. But the constitution does not say that. You are making a relationship based on what the constitution says, so we'll have to go with what the constitution says. By the text of the constitution, that is not the right thing. Okay. So don't think like this and make a mistake. Okay. So it is based on what the constitution says. Which of the following is, I think 470 is done. Okay, come to the next thing. Which of the following correctly states the rule regarding further employment, which I think we already discussed. The only thing that you have to understand is that there is no scope for further employment to whom? Complete further employment is prohibited only for the chairman, but for other categories there is scope for reappointment in certain capacities. Okay, so this anyways you know. Which of the following is the constitutional function of the Finance Commission? What is the answer? Answer C is the right answer. With reference to the 16th Finance Commission framework, consider the following statements. It has been mandated to make recommendations for award period 2026 to 2031. So of course, whenever they even just put the year also, it goes without saying it is for a financial year. Okay, it is not a calendar year. Okay. It has been asked to review the financing agreements for disaster management funds. Yes, this is one of the specific terms and reference which has been referred to that. So this is factually correct. It is also concerned with the principles governing the augmentation of consolidated fund of the state to supplement the resource of the panchayat and municipalities. This is also part of the terms and reference. Alright, so anyways you don't have to worry because this is also a constitutional function and will always be part of the terms of reference as well. So which of the statements given above are correct? All the three. Consider the constitutional bodies and their articles. So how many are correctly matched? NCSC, NCST and NCBC. So all are correctly matched. So what is the answer? Option C is the answer. Which one of the following correctly describes the GST Council? What is the answer? A constitutional body chaired by the Union Finance Commission, which is under Article 279A. Relevant amendment is 101st Constitutional Amendment Act. Which of the following is a function of the NHRC? Basically, what type of body is NHRC? It's a statutory body. So, what is the function of it? Enquiring into the compliance of violation of human rights. Which one of the following is our statutory body? So, can you give me an answer for this? So, among the above, which of the following is our statutory bodies? National Commission for Women, National Minorities Commission, GST Council, it's a constitutional body. National Commission for Scheduled Tribes, constitutional body. So, we are left with option A. So, this is again part of your current affairs. With reference to general consent for CBI, which one of the following is correct? Have we discussed the general consent already? Okay, what is this general consent? So, as per the Delhi Special Police Establishment Act, which is the law from which CBI derives its power. Now, many students have a misunderstanding thinking CBI is a statutory body because of the Delhi Special Police Establishment Act. A body does not become a statutory body because it is deriving some power. A body will be a statutory body if the body is established by that act. CBI is established by an executive order only, but continues to derive powers from Delhi Special Police Establishment Act, where it says that if they have to make any enquiry that in any of the states respecting the federal provisions in the constitution, that they have to take the consent of the state, subject to some exceptions. Okay. So, instead of taking the consent every time, there is a provision for what is called as general consent, which means otherwise a state object, it is assumed that the state has given permission for the next 6 months. That is basically what is called a general consent. Now, some of the states, because of the conflict between the center and the states, some of the states have already started withdrawing this general consent, saying that the CBI has to take the consent on case to case basis. Okay. So, what is the answer in this? So, general consent means the state gives a blanket permission to CBI to investigate in specific categories of cases without seeking the consent on case to case basis, but this general consent is usually for a period of 6 months, which is renewed after 6 months if the state does not object. Which one of the following is correct conditions for a person to be registered as a voter in an electoral roll? Citizen of India, attained 18 years, ordinary resident, and also further not disqualified under any law. Which law may disqualify? RPA 1950. Okay. With reference to the special intensive revision of the electoral rolls, it is a form of electoral roll revision undertaken by the Election Commission of India as per the requirement. Under which law? RPA 1950. It is linked to the verification and updating of electoral rolls. It can never be conducted once the electoral roll has already been finally published. Still the Election Commission of India can do it if they feel that they wanted to still revise it. Okay. Because anyways the electoral roll is something that it is not a one time job. It has to be periodically updated. So, what is the answer here? Which one of the following is correctly matched with the Representation of People Act 1951 as a ground for disqualification for membership? Mere defeat in election, conviction for certain specified offences, failure to attend parliament for one session under the RTA, loss of party office under the Representation of People Act. So, the most party office has nothing to do with the election. Party office means they may not give ticket from that party, still he can contest from other party as an independent candidate. Conviction for offences under the for specified offences. So, this is for specified offences or for that matter any criminal offence, provided the offence is so much, the conviction is more than 2 years. Under the present law, a candidate can contest election from maximum of 2 constituencies. Okay, which of the, with reference to the corrupt practices under the Representation of People Act, this bribery, undue influence, appeal for voters under certain prohibited grounds such as religion, race, caste, whatever it is, booth management by authorized polling agents, that is something they can do. Okay, so that is not a corrupt practice. So, consider the following with reference to corrupt practice. Which of the above are corrupt practice? What are the corrupt practices? This, and this. This is legal. It is legitimate. Okay. So, it is not an electoral offence. Who said it is an electoral offence? See, every party can have an authorized booth agents to see whether the voting is happening as per the law. So, that is very much. Booth capturing is different from booth management. Okay. So, do not confuse between booth management and booth capturing. Okay. So, the right answer is 1, 2 and 3 only. Booth management basically means they will help the people, they will guide the people, they will tell okay this is how you have to vote, so that people who may not be literate enough, they may do the voting wrongly, they may help the people who are coming to voting, they will provide all services at the time, because getting vote is very very important for time being. So, that is basically what is booth management. Yes, booth capturing is still not a corrupt practice. Booth capturing is an electoral offence. Okay, but still it may be right here. But booth manage, my idea is booth management and booth capturing are different things. Okay. With reference to consequences of a national emergency, consider the following statements. The executive power of the union extends to giving directions to any state on any matter. Is it true? Yes. So, what will happen to the state executive at that time? They will be there in force, but they become a subordinate. Okay. The parliament becomes empowered to make laws on item on the state list. Can the state legislature also make laws? Yes. The life of the Lok Sabha may be extended by the parliamentary law for 1 year at a time. Yes. So what is the answer? It is C. Which of the following are the consequences of financial emergency? The union may give directions to the state to observe the canons of financial propriety. Yes. Yes, the salaries and allowances of persons serving the union, including the judges of the Supreme Court and High Court, may be reduced. President may direct money bills of the state may be reserved for his consideration after being passed by the state legislature. Yes, this is true, but it is not only with regard to the money bills. It may be regard to certain financial bills as well. Okay, but the statement here is right. So basically, when I talk of financial bills, it may include financial bill type 1 as mostly. So certain financial bill is the word, including the money bill is the word that is used. So what is the answer here? It is option D. With reference to the President rule under Article 356, answer the following statements. The President can proclaim President rule if he is satisfied that the governance of the state cannot be carried out in accordance with the provisions of the Constitution, which he can do so with or without the report from the governor. That means basically the governor report is not mandatory. Such a proclamation must be approved by both the houses of parliament within a period of 2 months. Is it true? Once approved, the President rule can continue indefinitely without any further parliamentary approval. Is it true? So once approved, the President rule can continue indefinitely without further parliamentary approval. But what is the necessity? Every 6 months it requires a parliamentary approval, and also the President rule can go up to how much? Only period of 3 years. That too, if he has to go up to after 1 year, there are certain conditions. What are the conditions? First of all, there has to be a national emergency throughout the India or in some part of India where the state is also there. Second is election commission has to certify that it is difficult to carry out the elections. Okay, so once approved, the indefinitely is wrong. So what is the answer here? 1 and 2 only. Come to the next thing, which is related to the preamble. The word socialist secular integrity was inserted by the 42nd amendment. Yes, the preamble is part of the constitution. The preamble can never be amended under any circumstances. We already have an example for that. So what is the answer? Is the preamble part of the basic structure? The preamble is not part of the basic structure. If a question comes, the preamble is not part of the basic structure. The preamble does contain certain basic features. So therefore, you can amend the preamble without disturbing the basic features. So the answer is 1 and 2 only. Which one of the following correctly states procedure under Article 3? So the Parliament may do so by an ordinary law, but only after the President refers the bill to the concerned state legislature for expressing its views within a specified time, which you know, but the opinion is not binding upon the President. Which one of the following best describes the meaning of Article 11? What is the answer? It empowers the Parliament to make law with regard to dealing with the acquisition as well as the termination of the citizenship. With reference to citizenship in India, consider the following statements. The Parliament has the power to regulate citizenship by law, which is because of Article 11. The Citizenship Act provides acquisition of citizenship by birth, descent, registration, naturalization, incorporation of territory. State legislatures can independently make laws on citizenship? No. So this is not a power because citizenship is an item in which list? It is item only in the union list. Only they can regulate this. So what is the answer? 1 and 2 only. With reference to Article 368, consider the following statements. A constitutional amendment bill can be introduced in either houses. It must be passed by both the houses by majority of total membership of the house and also not less than 2/3 of members present and voting. In case of disagreement between two houses, a joint sitting can be called. There can be no provision for joint sitting in case of a constitutional amendment bill. For the reason, Article 368 clearly says a constitutional amendment bill has to be separately passed with special majority in both the houses. Okay, so maths is following. So tell me the answer. 104th Constitutional Amendment Act, is it correct? 104th Constitutional Amendment Act has given extension to reservation to scheduled caste and scheduled tribe, because do you know that this extension, that initially when the seats were reserved to the scheduled caste and scheduled tribe for the various constituencies, it was only for the period of first 10 years, as similar to that of for the women. Right now it is only for the period of 15 years, but which will likely be extended. So similarly every 10 years it was extended. So similarly in the original constitution there was also provision for Anglo-Indian nomination, that was also only for the period of 10 years, which has not been extended by the 104th Constitutional Amendment Act. For a scheduled caste and scheduled tribe they extended it. 105th Amendment is related to what? Restoring the powers of the states to have their own backward list. So this also we have already seen that. 106th Constitutional Amendment Act related to reservation of women. So what is the answer? It is all the three. Which one of the following correctly distinguishes the 5th and the 6th schedule? 5th schedule is related to what? Administration of scheduled areas, whereas 6th schedule is related to tribal areas, which is with more autonomy. In fact, there is a autonomous district councils and the regional councils which they can have, based on which they can manage. So I think you will be in a position to answer very simple questions. These are all areas which UPSC normally picks, so be clear about all those things. 9th schedule is related to protection of laws placed inside the 9th schedule by virtue of article 31B. With reference to 10th schedule, which of the following statement is correct? It deals with what? It contains provision related to the anti-defection law, option B. With reference to Lok Adalats under the Legal Services Act 1987, consider the following statements. Lok Adalat can take up cases pending before a court. Now there are certain cases which the Lok Adalat, in fact a Lok Adalat directly people can go to the Lok Adalat, or they can also take up cases which is pending in a court of law. They have to seek the permission of the court and they can come to the court. So both the type of cases can be entertained by Lok Adalat. But however, if it is a criminal case, only offences which are compoundable in nature can be taken up by Lok Adalat. So basically the idea of compoundable offences means, in the legal meaning, is that these are offences not very serious in nature. Basically there is a provision for out of court settlement. That is basically what is compoundable offence. So only in case of criminal offence, if it is a compoundable offence, they can go to Lok Adalat. They can take up certain civil cases also, ADR. So it is the Lok Adalat. And whatever is the order that is passed by the Lok Adalat, that is final and binding. Then there can be no appeal on that, because anyways it is not part of the court system. Only when it is part of a court system you can make an appeal in the higher authority. It is completely an out of court settlement. So there is no appeal against them. So what is the answer in this case? So Lok Adalat can take up cases pending before the court is true. Lok Adalat can also take up cases in a pre-litigation dispute, that is also true. The award of the Lok Adalat is deemed to be a decree of a civil court, that is also true. So what is the answer? All the three. So when I say it is considered to be a decree of the court, means that it is binding, final and binding upon the parties. So what is the answer? Option C. Can the Lok Adalat entertain both civil and criminal cases? Yes, it can entertain. The concept of compoundable offence will come only when it is a criminal in nature. For civil and criminal offences, otherwise the act itself specifies what kind of disputes they can take up. So normally these are all very petty disputes like traffic challan violation, electricity bills, all such civil disputes can also be taken up. So come to the question number 497, what is the answer in this case? Can anyone tell me? It is a village court established under the parliamentary law to provide access to justice at the grassroots level. See, here it is not an alternative dispute resolution, unlike the Lok Adalats. Here the idea is only to provide what is called as mobile courts. Instead of people going to the courts, the court will come to the doorsteps of the people. But here the person who will be passing the order is part of the judicial system. So therefore, whatever is the order that is given by this particular individual as a part of this court system is subject to appeal, because it is part of the court system. Is that clear to all of you? But however, the only thing you may keep in mind is before passing the order. So here there is also a possibility of what is called as for a provision for conciliation. So they can try for conciliation. If there is a possibility, they can try it. Otherwise, the judge will pass the order. The provision of Panchayat extension to scheduled areas act, PES act, are enacted primarily to what? In the 5th schedule areas. So 5th schedule again very important, which UPSC has been focusing upon. One of the important provision of the 5th schedule area is that the 5th schedule protects transfer of tribal lands to the non-tribals. The governor has authority to prevent this. This you remember, but I think the other things also we already discussed. So just go through your notes once before going to the exam. But anyways, from the 5th schedule and 6th schedule, very simple questions are asked. With reference to the official language provisions in the constitution, consider the following statements. Hindi in Devanagari script is official language of the union. The form of numerals to be used for the official purposes of the union is international form of Indian numerals. The constitution declares English as a permanent official language of the union. No, it is only for the first 15 years. Then thereafter it is subject to the law that is made by the parliament. So what is the answer? It is 1 and 2 only. Which one of the following correctly describes the budgetary process in the parliament? Budget is presented, then discussed, demand among the demand for grants, vote in the Lok Sabha, expenditure authorized, and then appropriation bill, finance bill. Now here you should remember a number of things. Please listen. Please listen. I'll leave you in a minute. Okay. So here you should know a number of things. Say for example, you should know what is charge, made, expenditure, difference between them. Then you should know what on demand is a prerogative of whom. You should know the idea of cut motions. Then what on account, what of credit, different types of grants. So you may expect one question from this particular area also, very important. All right. So with that we are coming to the end of this revision course. So try to do my part. So I hope that it will be useful to all of you. But again, as you already did today, you try to go and revise this also. Okay. Revise it, and I would say do not put too much of time upon the current affairs, at least for the subject polity. I try to touch upon some 15-20 topics. Mostly it may come from there, but nobody can guarantee. But even if they go beyond this also, hardly 1 or 2 questions may come. So your focus is, you should know that where the questions are coming, those areas you should focus, and put your time. If you have the time, focus on the other areas where you are not very strong enough. Okay. All right. So thank you very much and all the very best. Okay. Thank you.